Good morning, good morning, good morning, or should I say hear ye, hear ye, hear ye, because today is the day for the jury charge conference. No jury is present today. What does jury charge even mean, Emily? Well, charging the jury is what they call it when they send the jury back to deliberate and they read out all of those jury instructions. It will take over an hour to read all the jury instructions to the jury, and there's a set of instructions they get before closing argument and then after closing argument. And the attorneys will argue in the middle, the prosecution going first, then the defense, then the prosecution with their rebuttal argument. That doesn't mean that the prosecution gets double the amount of time. They have to split their time over those two arguments. The rebuttal arguments, you want to keep it simple, address the points the defense made. Those initial closing arguments from the prosecution, you want to see them lay out their theory of the case, go through the jury instructions. How do the facts of this case meet the elements of the crime? And for the defense, it's the opposite of that. You get their theory of the case and then the jury instructions on how these elements are not met. But what instructions they use is decided today. We also heard at the end of court yesterday that they're going to be arguing for dismissal again. That's not going to get granted, but we're going to see that argument again, saying that no reasonable jury could find these causes of action. The defense argued it before. They're going to argue it again. It's going to be roughly the same argument. Probably get a preview of what they think about the case, but the court's going to deny that. That is what's going to happen. And that is not a surprise to me or anyone. It is incredibly rare that those get granted during trial, exceedingly rare that those get granted during trial. So we're going to do that today. We're going to see the charge conference. How long will the charge conference last? It just depends. But I am interested to see if there is a stronger argument regarding a charge to the jury about the holes in John O'Keefe's hoodie. We know that that keeps getting put off and off and off and off, but we will see. I'm curious to see where that goes. Are we going to see a argument a little bit more about the DNA now that there's no rebuttal case? Because the Commonwealth was like, well, we're going to have a rebuttal. We're going to have a rebuttal. Well, now there's no rebuttal. So what are we going to see with that? And are we going to see that missing witness, which is really a necessary witness charge? It doesn't mean someone's actually missing. So a missing witness charge, we will see that. I really thought after how hard the Commonwealth fought for those rebuttal witnesses that we were going to see them. And yesterday, at the end of the day, it was just like, wah, wah, and we're done. I'm still surprised that Brennan was just like, yeah, we're done. He fought and fought and fought and fought and fought for that rebuttal. I think even the court was shocked, just absolutely stunned. Let's roll the intro. Let's get to court. Again, no jury today. How long will court be? We will see. So who knows? But don't forget, members, we will do a members only live today. It will be probably around 3. It's just going to depend on when court ends. So I will let you know in all the member spaces. I wish I could just roll this into that, but around 3 Central is what we're thinking, but it's going to depend on court. If court ends a little early, we might bump that up a little earlier. Either way, let's go to court. That's not the intro, Emily. Wrong button. It's not time for questions yet. All right, well, I'm hitting the right button. Let me know where you're coming in from, what you're drinking, because, you know, it's a beautiful day here in Middle Tennessee, and I have a cappuccino that I made this morning right before we went live, so we're ready to go. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, it's going to be time to get to court, so let us go. It is time. It is time for court. I do not hear much from court. See if I can gain that up. Do you hear that? I don't hear anything. All right, hold on. Let's see if we can gain that up a bit. Sorry, chat. Streaming is dynamic. I heard them call the case barely, but that was about it. Oh, that's better. I can definitely hear now.
Good morning, Your Honor. May I call the case? Please.
It's still
For the
quiet.
record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please
still a bit
identify
quiet.
themselves for the record.
All right. They say the matter is on for trial, but the matter is on for trial conference, which means there's no jury present, just so there's no confusion. I'm going to see if I can gain this up just a little bit because that was annoying. All right. Let's see if that works. Optimistic. I'm optimistic. Oh, that's a bit better.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan.
I'm not
morning,
confident
Mr.
in
Brennan.
sound today.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti.
That's better.
Good morning, Mr. Yannetti.
Thanks,
and
chat.
good morning, Ms. Reed. All right.
Every day
Mr.
is an
Yannetti and Mr.
adventure.
Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right. So, first thing we let.
Are any of you surprised that Jackson is not in court today? Anyone? Oh, it looks like some of you are surprised. He's working on closings. They don't need him today. He's working on closings. Yannetti is going to argue in court. We're going to see argument in court, I'm sure, from Alessi. Jackson has the benefit of being able to take today to work on closing with Attorney Little, who is a member of Jackson's firm, one of his right hands, and also is going to have the entire list of all of the evidence, all of the things. So he's working. The benefit of him being able to take today not in court to work on closing and trust the rest of the defense team to get stuff done, and then for Brennan to be in court all day and then have to work on closing is a huge benefit to Alan Jackson. So, I am not surprised that he's not in court. It is a big advantage to him with being able to prep his closing.
Left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would.
This was something that they were fighting about yesterday, and we had not seen the ruling on that, and I'm very curious what's going to happen. Again, PowerPoints generally don't come in. They've come in a lot this trial, but they generally don't come in. So when there is an objection, I'm not surprised that now we're going to see what happens. So
would
all
be
right.
entered into evidence. It will not be based on the objection, so it is excluded from
All
evidence.
right, and they're keeping it out.
So it's marked still for identification, and your
Look, man, the defense could have objected to all the other ones they let in. They had a reason for letting them in. And if there was a stipulation between the attorneys that all of them were coming in, then they should have stipulated that all of them were coming in, which it doesn't seem that they did. So those things normally don't come into evidence. It's not like the court is keeping something out that's odd. I just wonder if there was some tacit agreement where they thought everybody's going to allow them in. But I'm not surprised that the Commonwealth all of a sudden is like, nah, I object. Jennifer said, why isn't Hank working on his closing too? Because he's got to deal with shit in court. And some of the shit is his shit to deal with, including the hoodie. So he's got to deal with it.
rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question.
Oh, also, if I'm Attorney Lally and Brendan's like, hey, can you handle this today? I'm like, nah, buddy. Nope. That situation with the hoodie and with the DNA and with the rest of it, that's all you, my guy. Good luck. Oh, no. No, I'm not. Nope. I wouldn't take over all of that for him.
First, as to whether the court would like to entertain the argument on the motion for required finding not guilty of all the evidence.
So, no, we can do that now. So now that my ruling is on this,
Now
evidence
we're
is
done.
closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required.
Take your time. Now, take your time. Now we get to take your time. Okay. Everybody got an extra hour of sleep today. Everybody feels a little better. Somebody had a Snickers. Everybody got a little snacky snack. Now it's take your time. I saw a number of you ask me, What does your rights are saved mean? The court is just saying, and this court has her own parlance entirely, but it's, you've made your record. Your rights are saved for appeal. You've made your record. The record's been made. It's on the record. You'll often hear courts just say, you've made your record, or the record's been made. Your rights are saved. The record's preserved. You objected. Remember, when it gets to appeal, if a case gets to appeal, I don't want to say when this case gets to appeal because it'll be interpreted as if I'm insinuating something. If a case gets to appeal and the attorneys don't object at the moment, then your rights are not preserved on appeal. You have to raise the issue when you are in court. You have to object then. You have to argue it then. If the defense sits by and doesn't object to something and then on appeal says, hey, what about this? Your rights were not preserved. You did not object at the time. So it's her way of saying the record's been made. That's all. She does that with objections sustained. Half the time she'll say, I'll let you have that, or I'll let them have that, or ask it a different way instead of saying sustained or overruled. So this court has their own vernacular.
Finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth's case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition.
Also, yes, the feed does look a little blurry to me too. I don't know if I do, and I don't know if that's on YouTube's end, but the feed does look a little bit blurry. It's not you. I see it as well, and I suspect that is a YouTube end.
Recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning. On January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month,
argue that.
the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian
The court's
Higgins.
following. The court's like
who
Higgins,
is on
right?
video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
Yeah, that's not going to happen. But okay. I know the court sound is not great today. Yeah, that finding's not going to happen. Let's see if we can gain it up a little bit
Thank
more.
you, Your Honor. Commonwealth requests that the defendant's motion for required finding
Be
not
denied.
guilty at this juncture as it was
I'm kind of surprised Lally's arguing this. Okay.
at the close of the Commonwealth's case be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate
Trooper B testified about the dog.
to there being an absence of a dog there. The arguments from counsel of the Commonwealth would suggest grossly exaggerates the strength of the defense witnesses in their case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. Laposada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see,
I don't know what that has
from
to do with anything.
The cruiser camera video drove by the scene countless times.
The body temp's a good
essentially,
point.
Rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and request
Right.
that the defendant's motion be denied.
The standard is the thing. The standard is everything. The standard is everything taken in the light most favorable to the Commonwealth. Then must the case be dismissed, and that is a very, very difficult standard.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the
I had to
motion is
turn this up.
denied.
Thank you, Your Honor.
Okay?
The court denied that.
All right. So regarding the charge, so we'll start with the defendant's missing witness request.
I wanted to hear this. Also, these motions get denied all the time in all of the courts. It is exceedingly rare that they don't get denied, or exceedingly rare that they get granted. The standard is in the light most favorable to the Commonwealth. Everything in the light most favorable to the Commonwealth. So now we're getting to the missing witness instruction, which is not that somebody's missing. It's that a necessary witness wasn't called. I'm very interested to hear how this goes.
Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions with shortened things today. I think it's,
Oh, okay. So everything on this is done, right? The defendant's motion to present a missing witness argument
You're
and request
withdrawing
for
it?
instruction. You're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay.
Why?
And what else from your proposed instruction?
Hey! What? All right. Well, the defense is withdrawing their request for missing witness instruction. Okay. I was actually really interested to hear the argument on that.
Instructions, you said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that.
Well,
All right.
darn it.
Thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's motion.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing?
So the defense has withdrawn their missing witness instruction request. The defense is still making a request for an additional instruction regarding the Hoodie, and we are going to get into the rest of the charge conference. So they are going to talk probably pretty quickly with the numbers of the jury instruction, etc. Interesting.
For the rest of the defendant's proposed instructions. Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking instruction on for the problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So, presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay, and I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal.
Oh, so we're going to talk about that, are we? I think it was clear, and I was upheld on that. The individual indictment instruction is talking about making a verdict or finding a verdict on each individual indictment. I think it was clear. I think we can make it more clear, though. I think we can make it more clear. So that's the instruction they're talking about now, about finding a verdict on each individual indictment. I was upheld on that. Okay.
Clear. Okay. So I'll give you that, Ms. Yannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Mr. Yannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you
That's
want to take a look
necessary.
at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden.
Okay.
I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to
The Commonwealth is now arguing the Bowden instruction. A lot of the instructions are standard. When it comes to things like the Bowden instruction, it is not a standard instruction. It's an instruction that needs to be requested. The Commonwealth is objecting. The court's going to give it either way. The Bowden instruction is an instruction regarding the sufficiency of the police investigation. So that's what the instruction is regarding. I'm interested to hear what Lally's argument of it is. I'm surprised that he's the one arguing these and not Brennan. Maybe Brennan's sitting in court working on closing and Lally's arguing this all today, but okay. So on the Bowden instruction, it covers sufficiency of the investigation. The defense has requested it. The Commonwealth is objecting to it. So Lally's going to argue that.
the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense.
Lally, the court specifically just asked you about Bowden and you're arguing third-party culpability and third-party culprit. Those aren't the same thing, my guy. Can you answer the Bowden question first and then hop over to the other topic? We're just conflating the two of them? Okay.
From actual evidence in the case, from testimony from witnesses from the stand, exhibits that were put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in case law on evidence. And obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or a third-party cooperation instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Yannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Yannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material.
She's going to allow them to do that.
The chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue the suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lally comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor.
This argument makes me so mad. It makes me so mad. They didn't put forth any affirmative evidence, right? Because the court wouldn't let them. The court wouldn't let them. They asked to bring in a police procedure expert and the court said no. Lally's like, well, they didn't put on this evidence. The fact that Yannetti's not screaming shows how early in the day it is and how restrained. Because good God, well, they didn't put on any affirmative evidence of that. They asked, and then they asked for reconsideration. The court was like, no, no, no. Oh my God. And Lally's like, well, they didn't do it. Stop it. They couldn't. She's going to let them have the Bowden instruction. And should.
We made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it.
Disingenuous.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to
allow it anyway.
Yannetti, I'm going to allow you
Yeah.
to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know. But tell me, are you going to argue it?
She's like, are you going to get up there and argue about Higgins? And here's the fine line. Let's take a second. Here's the fine line between Bowden and third-party culprit. We are going to go over the necessary witness stuff as we get at the end of the charging conference. I see you guys. I'm not forgetting you. It's a longer conversation, and I want to watch the rest of charging conference with you. But we will go over why the defense withdrew that to the best of our ability after we finish the charging conference. Bowden and third-party culprit are different but interrelated. The interrelatedness is that part of a Bowden argument, Bowden being a argument that the police didn't do necessary things, that includes following necessary leads. That means the defense should be able to argue, look at all this information about Higgins. He's texting Karen Reed. He's ghosted. Look at the video that night. He's texting John O'Keefe. Are you coming here? What are you doing this? What are you doing that? Not arguing that Higgins did something. Arguing that law enforcement should have looked into whether or not Higgins did something. The third-party defense is did Higgins do it? Like, Higgins did this. That is the third-party defense, arguing Higgins did it. The Bowden defense is, look, law enforcement should have looked into this. Look at the video from the waterfall. Look at the video from Canton PD. Look at the fact that his car was there. Look at the text to Karen. Look at the text to John. Look at. The police should have looked at it. And they didn't follow logical and necessary leads and look into other individuals. They did not do the investigation that they should do. That's the Bowden defense. The third party defense is arguing you have to find Karen Read not guilty because this person is the person. This person is the culprit. I think it's easier for the jury to say, look, I don't know what Higgins did or didn't do, but shit's sus. And if shit is sus, I mean, my summation, if shit is sus, I can't say beyond a reasonable doubt that it is on Karen Read. But it doesn't require the jury to go the next step to say, yeah, I am convinced that that is the right person. They can say, I don't know. The police should have looked at it more. And that's the Bowden defense. Lally is trying to conflate the two. And there is an interconnectedness there of, did the police follow necessary leads versus is this alternate person the perpetrator? I hope we have split that down enough, because they do seem interconnected in arguing the police should have followed these other leads because maybe that other person is more connected than we know, which is a nuanced argument distinct from that other person did the thing. So there is the connectedness there. Also, speaking of connectedness, as we started talking, I completely forgot that our stream has a lovely sponsor today. And we are going to take a moment to thank them, because we need a moment to thank them because A, our stream sponsors allow us to put less ads in streams. So Replay Crew, love you, always thinking of you guys. B, it makes sure that Team Baker gets well taken care of while we are in trial, and that we make sure that the case briefs come out to you in a timely fashion, because the amount of work that Team Baker has done is absolutely incredible. And because Team Baker is doing that work in connection with me and in conjunction with me, it means I still actually sleep during trial, which is critical, or we're not going to survive the rest of 2025 if Emily doesn't get to sleep while we're in trial. So a massive thank you to our sponsor today, Incogni. This is a service I use. I share it with you because it has been necessary and helpful in my life. And you know, I appreciate sponsors that make things simple. So a huge thank you today to Incogni. Hey, Leonard, I know you've probably been checking to see if your information on the internet is up to date, you know, like your LinkedIn. But have you been checking to see how much of your private information is on the internet? And as phishing attacks are getting more sophisticated, not only by email, but also by AI voice-generated attacks, a lot of the current schemes are not going after the technological weak points, they are going after the human weak points. So why not get that information off the internet before someone has the chance to use it against you? And I know that sounds like a lot of work, which is why I am partnering again with Incogni, the sponsor of today's stream, to bring you an incredible discount on a service that honestly, if you exist on the internet, you need. I have used Incogni to remove my information from hundreds of data brokers, and not just information from me and my spouse, but my parents, my siblings, and my teen. Incogni also has family accounts so that you can bring everyone in your life in on making sure that your information is removed from those data brokers that are making money off of making you less safe. Emily, does that piss you off? Yeah, a lot. So to get an exclusive 60% off an annual plan with Incogni, just use code EmilyDBaker at incogni.com/EmilyDBaker. That's 60% off an annual Incogni plan when you use EmilyDBaker at incogni.com/EmilyDBaker. Don't worry, it'll be linked below and in the chat. So let's get back to today's stream. And yes, it does 100% piss me off that there's an entire industry that takes your data, puts it on the internet and sells it to people. Yeah, it pisses me off. I hate it. I don't like it. And we've seen witnesses in this case, including Dr. Wolf, complain about their information being out on the internet, about their families getting doxxed. It is a growing problem. Also, I would recommend, and then we will get back to all of court, a family passcode. It's time. If your kiddos are old enough to be calling you and with your parents, it is time for a family passcode with your siblings, with the loved ones in your life, because those voice attacks are getting better and they trigger that flight response in people with a fake call that somebody's in like catastrophic peril, and then all of a sudden they need your credit card information or something. You need a family password. I know it seems like overkill. You need a family passcode with the people in your life because it is a huge and growing problem. And it is something that's hard to explain to people that are just like, wait, what do you mean it'll sound like you and it might look like it's coming from your number? Yeah, that's a yes. And it's terrifying. All right. For all of that, let's continue on, shall we? Let's continue on to court. I have done my technological rant for the day about keeping yourself safe online. Let's continue on to court. The court is giving the Bowden instruction. Hopefully we now know the difference between Bowden and third-party culprit, and the court's going to get into that conversation too.
Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert.
Correct.
So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party
And they're
culprits,
not.
has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into
Necessarily,
third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
That's crystal clear, Judge.
Okay.
Yeah.
What I would say for this clarification based on the
Yeah.
pre-trial.
So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do.
It's a better argument for the defense, I think. Hey, look at all this stuff. And it wasn't investigated. It is I think, a stronger argument. I think it's a better argument. We knew the court was going to give the Bowden instruction. She's been on board with Bowden from the beginning. And the standard for the defense to meet for Bowden is much lower than the standard for third-party culprit. The third-party culprit is a much higher standard. I also think it feels like overreaching. And when the defense overreaches, the jury tends to tune out. I don't think it's overreaching to say, look at all this stuff with Brian Higgins. Why didn't you do more? That is a completely fair argument. And I think a lot of people who might not be on board with these other people did a thing might be on board with, yeah, why didn't they investigate it more? Is it because they're all cops? Is that what it is? And if they didn't investigate it more, then how can we say for certain that the person sitting here in court's the person that did the thing? It is a good argument. It is a good argument for the defense. And I think it's easier for the jury to follow.
Pure third-party culprit. Okay, that's great. That makes that easier. So
They're
I
not
will
trying
give.
to.
I'm sorry.
Sure, go ahead.
While we're on page 8, I just wanted to, Alma does have an objection to the teacher instruction that's at the top of page.
God damn it.
Yeah, I have.
We have gone from Brennan screaming at everybody in court so that he can be heard to Lally speaking under his breath. I understand why Lally's not projecting because the court's literally like right there, but it is so hard to hear what he's saying. It's just Lally's objecting again. So, okay.
Sure, go ahead.
While we're on page 8, I just wanted to, Alma does have an objection to the teacher instruction that's at the top of page 8.
Yeah, I have a check mark next to that. Ms. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So Obviously it's not the strongest DG Batista argument that we would have. It would not occur at a police station, but, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on their own cell phone. It could have been done. It wasn't done. We have to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to the.
Do you think it was custodial interrogation?
No.
Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was custodial.
Not a good one.
Custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounding her.
That is not your strongest argument.
Familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered.
Not a good argument.
All right, what do you say about all this, Mr.
And
Hill?
I would also add, Your Honor,
Sure.
That it's not custodial.
Deal at around the same time. So, that it goes definitely to the issue of custody and.
Yeah, that one's a no.
Being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the troopers spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, over the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present. No one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody. She wasn't arrested. Yes, they did seize her cell phone and her vehicle based on information that they had developed from the course of the day and from statements from Ms. Reed herself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within saying requested jury instructions or request for humane practice, and then following the DAG and Batista language in the defendant's requested jury instructions, there goes on to all of this other requests regarding her compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context of humane practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with.
The court asked Lally to finish his thoughts on the absence of recording argument, and he is now jumping into another topic. It is also exceedingly hard to hear. The absence of recording is an instruction the defense is asking for. One of the necessities there would be a custodial situation, a custodial environment like a police station. Karen Reed was at her parents' house. It was not a custodial interrogation. She was not in custody. She was not taken into custody. She was not under arrest. She was not detained. So they're not going to get that instruction because it just doesn't fit with the law. But he is moving on to argue about a few other things, which we will get to, I'm sure.
Sergeant Buchanan didn't have his testimony from the stand, that initially she said she was fine with answering questions, but didn't want to get into any details. And then when the questions became more centered on details, at that point, and I know that's not evidence to the jury, but as the court is well aware, she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state during the course of this interview. And I don't think that arises to the level of the DC's instruction. So I would ask basically that everything on page 8 prior to the Bowden Instruction be excised.
All right.
I've tried to gain Lally up. He is hard to hear. And so now, because we've got it gained up to try to hear Lally, we hear the court reporter in the background as well. But no, Karen Reed was not arrested the 29th. And yes, they can seize property without taking her into custody. 100%.
I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at the residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
If it's gonna happen, it should happen once, not.
Yeah.
I think that's fair.
Okay. Okay. All right. Prior statements, I will give some instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn, so is the...
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view was not present on January 29th. We asked her to repeat that one sentence.
Okay, so I did not see this when I took a quick look at the view. All right, I'm not going to repeat it. All right, lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
I mean, the law enforcement witness instruction should just go with the expert witness instruction. Why do you have them in such a weird order?
Language in there, I would object to it.
Okay.
Testimony of a police officer or someone else.
Did Lally say he's objecting to that?
Law enforcement witness, I think I gave
to
some
back up.
instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there, I would object to it.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
Oh, what do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language comes.
Okay, thank you. I'll do.
Lally objected to some of the language in that instruction, and Yannetti said we can modify it to just this, and the court said that's what I'm going to do. So we will hear that full instruction tomorrow. It's just about not giving law enforcement officers undue weight just because of their job.
The photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just as far as photographs,
What
What do you
page?
mean you're not going to give exactly this? Give them the language of the jury instructions because they're going to use it in closing. When are you going to give them the edited version then?
Page you want? Okay.
one suggestion there was indicates now Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your
Okay.
objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right, so
The SJC is the Supreme Judicial Court. They oversee a lot of the writing of the jury instructions. So it's going to be verbatim. Most of the general instructions should be verbatim, just exactly what's written in the model instructions with relatively few modifications.
the Commonwealth's
What?
requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally, so let's skip to your,
Oh, this will be interesting. Let's talk about the law.
it's not
Yes,
numbered,
please.
your supplemental instructions, use of a dangerous weapon.
Yes.
All right, so I'm going to give that, Mr. Yannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
Yes, cars count as a dangerous weapon. Yes, that's standard in all jurisdictions if there is a weapon involved. I've seen dangerous weapon instructions on skateboards, baseball bats. If there is an implement used in a crime, there is generally a dangerous weapon instruction.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Yannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks. And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find or something, preface it. Witnesses, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during.
Are you going to tell them that it's okay to eat lunch? I'm just curious. I'm being snarky. That's not going to go in there.
Trial. During the course of the trial. I'll just say when preparing for trial.
Yep.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right.
I would just modify that line out then.
Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction.
That's not in evidence in this case. Why do you need a prior bad acts instruction?
Before that testimony came in, I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right, so
the court has said that Aruba was mentioned through John O'Keefe's niece in testimony. The defense withdrew their objection to it. The prior bad acts instruction is going to come in, and we will hear that instruction in full when they read it tomorrow, but it's regarding a confrontation in Aruba. So the jury heard that with Kaylee. We didn't see any of that because with the niece and nephew, those were not televised at all.
Did I give it any other time that there's another event that I should highlight? I don't think so.
Gave contemporaneous instruction regarding the text of the case.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So
We would object to the part of that act being linked to the beginning's text message.
all right, I'm going to take a look at that, Mr. Alessi. All right.
Did she just call
Consciousness
Yannetti
of
Alessi?
guilt.
Your Honor, Collins is on.
Okay. All right.
Huh.
All right.
The Commonwealth withdrew their consciousness of guilt instruction. Okay. The Commonwealth had argued that removing the vehicle was consciousness of guilt. It wasn't a good argument, but that was their argument. When Karen drove the car from One Meadows back to her parents' house, that was her removing the murder weapon. I'm sure some of you remember those arguments. They're withdrawing that instruction, so it won't be given to the jury.
So tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Your Honor, so the only,
1 second, let me just pull that up. Okay.
Your Honor, Collins' request is merely not for any change or alteration in the instructions that were given, other than there are three prongs of malice, and essentially the Commonwealth.
And yes, he is miserably hard to hear. Miserably hard. It is so hard to hear.
Is requesting that the jury be instructed
Speak up.
merely on third prong malice, because that's the only
Well, thanks, Your Honor. The law nerd chat appreciates it. We can't fucking hear anything he's saying.
one that really applies to these factors. So
Okay.
the Commonwealth here, the first two prongs are essentially strangers in this situation, and you don't need to explicate the jury to avoid confusion.
Do you have supportive case law for me to single this out?
I do.
What do you say, Mr. Yannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, did not intend to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll refer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model.
Why are we arguing over the model jury instruction for second degree? Like, why do we need to modify it? Just give the model instruction.
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support
The Commonwealth is asking to modify the instruction, and I think with the court, it's just give the model instruction. I hear that the prosecutor is asking to change it. The defense has said they're not feeling strongly one way or the other, and then you go with the model instruction and you don't modify it. There has to be a second degree instruction. So just stick with the model instruction.
the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. But I understand, and I don't certainly want to.
You know, I suppose I could always tell the jurors that.
And the defense is saying no. She's saying if both of you want it modified from the second degree, or the model jury instruction modified, it might be that there isn't its own second degree instruction, and that both parties are like, can we just narrow this down? Why wouldn't you just have a second degree instruction? It's very confusing to modify a first degree instruction.
The Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something.
that's
If I can
why.
find something that says I don't have to give those first two prongs, I'll let you know before you begin.
Well, that explains why. That explains why, because the SJC has modified the rules, and the SJC is like, you have to read them all. Well, that makes sense if the SJC has modified the rules to say these have to be read, and then you have to read in the instruction and say, but those things don't apply. It gets confusing. The attorneys are saying, if it doesn't apply, can we just say it doesn't apply? Please?
And Your Honor, before the court makes a decision on that, we see what the court is proposing if you are going to alter the penalty.
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right, so lesser included offenses. Did you want an OUI instruction? You were.
We're asking for that.
Which ones?
All right.
No one's going to the mic today. We'll talk about the prongs later. Don't worry, we'll talk about the prongs later. It'll come in more tomorrow because we're going to talk about shit today that's going to get modified before the jury hears it tomorrow because we're not going to have the final jury instructions. But each jury instruction on the charge has different elements. If some elements don't apply, then they have to say this element doesn't apply. But we'll get to that after we get through the
Right, I
charging
think that's
conference.
it, aside from Mr. Alessi's motion regarding the exhibit.
So they're done
Right,
with charging.
is there anything else that we're missing?
Just a couple of other issues. One is with regard to the proctor text messages, we have a redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay.
But it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it. But I'm going to give it to them now.
So those are the redacted text messages to substitute into evidence.
Sure, thank you. All right, so
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it, so.
Commonwealth, you better agree.
I do not believe there's going to be any problem.
Okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced in evidence from.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't?
We have them redacted, so we
Okay.
redacted. It's on a phone drive.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
Somebody's got to look at it.
Will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes. All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor. If I didn't.
You did not.
Okay.
I'm not surprised by that.
We've got 2.
Yannetti has a proposed verdict slip for count 2. That was also much discussed last trial because there was some confusion with it. So this is the verdict slip for count 2. Katie in the chat said, Emily, is it always this complex? This is not actually a very complex charging conference. This is a pretty bare bones, easy peasy charging conference. So far, this has been a 95% in agreement, a few modifications. This has been fairly simple. Jury instructions are complex. This has been a very streamlined and simple charging conference. So I know it feels like they're speaking a foreign language because they're speaking in shorthand. They're not talking about this for everyone else who's watching. They're talking about this. They all understand what they're talking about. Hopefully that helps. Okay. So this is an updated verdict form.
Okay. Sure. Is it the same as last year's, but now with a...
It's different.
All right. That's a modification from last year's.
All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually Yannetti.
Yannetti. Jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument.
That's funny. I'm going to back that up. He's just like, I'm Yannetti. She's like, oh my God, we're tired. We're tired. That's funny. Do you need time to digest it? No, I've digested it. This is argument on the verdict slip for count 2. Count 2 involves numerous lesser includeds. That can get confusing.
Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually Yannetti.
Yannetti. Jeez, I'm sorry.
So, Your Honor, you'll recall we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each one.
The lesser included crimes all have subparts. Count 2 is a bit of a cluster because it's all very different. And then each lesser included has subparts to the lesser included. So it is not, of all of the things, count 2 and the verdict form for count 2 is not simple. However, I think part of that is on the attorneys to put count 2 up on the screen and walk the jury through the understanding. Because once you explain it, I think it becomes much more clear. Not explaining it is part of the problem.
Lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple.
But it was like not guilty to all.
Different types of guilty verdicts.
It was like not guilty, period.
So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, the same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the least, I should say, of the lesser included offenses is simple operating under the influence, where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least three of the charges, including the main charge, because there's this issue of either under the influence or .08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it, the defense requests it, that the court must give it.
What did you just say? 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 Did you just say the Commonwealth's not requesting any lesser includeds? What? Okay. Okay. I'm going to try to gain this up again because that's what I think he said.
As the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if
The Commonwealth is not requesting any lesser includeds. Okay.
supports it, the defense requests it, that the court must give it. Having said that, the verdict slip that was used in this matter last year, the Commonwealth would submit is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if Your Honor is aware, there was a case recently, while this case was going on, tried before Judge Olao, in which he had similar issues and I believe used at least part of the verdict slip from the first trial in this case as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court a copy with a copy of the docket, but that may be somewhat helpful with the court's thinking of that.
Okay, was that on a murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Okay. Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Lau is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're...
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
Okay.
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy, please?
Sure,
Okay.
yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LLLL for ID.
Okay.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instructions. So
All right. They are switching topics. Don't worry. We will get into more of this when we are done with the charging conference, but they were arguing over the verdict slip for count 2. The Commonwealth said they are not requesting any lesser included charges. However, unlike other jurisdiction, if the defense requests them, the court can still give them. In some jurisdictions, if the Commonwealth or the prosecutor doesn't ask for lesser includeds, then you don't get lesser includeds. It is that the jury has to decide on the main charge and that's it. That means the jury has no other option. It's either this one or it's nothing. Mr. Lally has said the Commonwealth is not requesting those lesser includeds, which means it's either this or nothing. And the defense is requesting lesser includeds. We're going to have to wait and see what lesser includeds the court gives because that's the verdict slip that they are talking about. I don't know if we will see that at the end of the case. We will talk about count 2 more when we get to the end of the charging conference. And the defense might be asking for the lesser includeds giving the jury somewhere to compromise. So we will talk about that more at the end of the conference because there will be lots of questions. So let's see what else Mr. Lally is asking for.
The Commonwealth is withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference in its argument to the jury related to specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some argument to the jury regarding is the defendant's taking of the Lexus from one metal dab can to her parents' residence indictment, and then certain statements made in reference from the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says it's identified to either her or me.
Okay.
Whatever the exact.
Lally, speak
All right.
up.
Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of.
Lally is arguing that even though there's not going to be a consciousness of guilt instruction, that they be allowed to argue to the jury that Karen Reed's statement about Jen McCabe, it's her or me, and taking the vehicle is consciousness of guilt. The defense is objecting.
To another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. And in fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
That's fair.
And just to be further clear, there may be other clips and statements.
Yes, so I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay. Okay, I just wanted to give you.
So the court said, I was not going to give this instruction at the Commonwealth's request, but if the defense requested, I will give it. And the defense is like, no, we do not want the consciousness of guilt instruction, even if they're allowed to argue the inference, they're not giving the instruction.
The opportunity. Okay. All right. Anything else? Anything else, Mr. Yannetti?
Yes.
We're going to hear
Alessi.
from Mr. Alessi, but
The Commonwealth does not object to the redactions.
that's great. Thank you.
And Ms. McLaughlin chimed in and said the Commonwealth has no objections to the redactions to the text messages, so those won't be discussed tomorrow. Those will just get substituted in.
One last thing you all have to do today. Okay.
This is Mr. Alessi.
I know. All right. So let's make that. Are we switching
Yes.
that new redacted version with the exhibit number? Do we know what it was
Oh
before?
my God, the sound.
Excuse me. The
sounds like-
redactions on the
It
Higgins
seems like the court can't hear them either with the way she's leaning forward.
messages. That's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications. Okay.
This is the testimony that came in.
Of Proctor, I was, yes. All right,
Right.
so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
They're going to need to go through their notes.
Okay.
Does the court have a copy or do they need the Commonwealth?
No, I wrote on it. I need the Commonwealth's.
So this is a clean copy. This
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
That makes sense.
No objection to that. And so original 209 will not be sent in. Is that?
it becomes
What do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209. All right, did we have an ID number on it originally?
I'm sure you did.
NNN.
Can it still be that?
Is it redacted, the NNN? Or is it, no, it can say that.
Okay.
Right? 'Cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no,
The court reporter, the clerk, and the court are now having a conversation, the three of them, about whether or not Exhibit 209, the unredacted exhibit, can be reverted back to marked for identification and then substitute in the redacted version as 209 instead of having it as 209A. This is housekeeping. So the housekeeping on this is they need to keep the unredacted version for the record. So there is a record of what was unredacted and a record of what is redacted. They are discussing the best way to do it. Don't worry.
oh,
We'll
it
get to the
became
rest of the stuff.
209.
Yeah,
So that has to
our
be-
thinking is it needs to be sent back to letters for
Yeah.
idea.
The
Yeah.
redacted
So
version.
it'll be marked MM for ID.
That's great.
Perfect, and then the redacted version will now just.
209.
Yes.
Yep.
So they've marked it as MMMM for identification. The redacted is going back to the jury as 209 tomorrow. And those are the proctor texts. Fine.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office.
And they can't go back on the record until the clerk is done marking everything or the reporter is done marking everything because the reporter marks everything and she can't report while she's marking it. So.
So, someone,
We're still waiting for Alessi's argument regarding a further instruction on the hoodie.
send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I'm
A few of you have asked, wouldn't M4 be easier? No, because then there's numbers. And the marked exhibits are letters, or the marked for identification are letters, and the marked exhibits are numbers. If you put a number into the marked exhibits that are letters, everything's going to get more confusing. So no. Now we're going to get to Alessi's argument regarding the hoodie.
I might suggest respectfully a procedure to the court. I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to extra.
I can actually hear him, but he was peaking a little bit. So I'm going to see if I can continue to modify the sound, but I can hear him pretty well. So we'll see how it goes.
Indict this matter. If I might suggest to Your Honor, to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and Introduction into Evidence of Exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's an appropriate instruction to give.
Well, God damn it. Now we just can't hear. We're going to have to deal with the peaking or we won't be able to hear the Commonwealth's argument at all.
What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's an appropriate instruction to give in the final charge. What Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't.
Lally said the instruction the court gave to the jury at the time is sufficient, so they don't need another one.
Require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you.
Please go to the podium. The Commonwealth has mildly objected, like most mildly objected. Like, we submit that's fine. It is not a strenuous objection. It is a, we object.
Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly.
It sounds like they just turned the microphones at the podium back on. Well, thank goodness for that.
But I think this...
We've gone the entire charging conference, and all of a sudden, the mics in the courtroom are turned on. Thank you, pool provider, for turning them on finally, so they don't have to be gained up. Good Lord.
Allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt. The subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led...
The holes where, Mr. Alessi? Here.
To a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that's...
Sir, I appreciate you're getting to the exact language, but we're just going to have sound issues today.
Starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened.
100% did that. 100% did that. He started to say, well, I know that there had been cuttings too. Cuttings from the lab. That's not unusual that the lab takes cuttings of material. And so Alessi's laying it out even more for the court. Look, the witness was starting to answer that way and then was cut off.
So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022
That's not gonna happen.
from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence.
The court might give the bulk of that. The falsely insinuating part is not going to happen. But the rest of it is not highlighting the issue while still discussing the issue. And the jury can decide if it was a false insinuation. But Mr. Brennan asked about holes in the back of the sweatshirt, and it is known by all parties, I think would be appropriate. It's known by all parties that these holes were caused by the crime lab. That says it without saying it. The court's not going to say that one lawyer falsely insinuated something, but you can tell the jury that they knew and asked about the questions, because I don't think falsely insinuate's going to get in there at all.
And so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant...
Excuse me, Alessi, you're only allowed to say what with emphasis. It has to be what happened in this courtroom, because you have now trained us to expect that you're going to say what that way every single time. Please. Thank you.
Topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue.
That's facts.
So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them. But I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error. To me,
agreed. It's
respectfully,
undisputed.
all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in.
What?
That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for that. I will, and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
And the court is saying, if it wasn't shown to you at the time, you should have objected and said, excuse me, Your Honor, the Commonwealth has not shown us the exhibit. That's what the court is getting at.
Very briefly, Your Honor.
Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor.
The court, keep your voice up, Mr. Lally. The court is so close to where he's sitting and still can't hear him.
Point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen, mistakes can be made. It was recognized, acknowledged, and...
Oh, court reporter for the fucking win. Thank you, Madam Court Reporter. Just a win. Just a win. Just an absolute win. Pushing the microphone over at Lally's face. Just thank you. Now, why is Brennan not arguing this? I have no idea. Is he working on his closing? Probably. I don't know. But now we finally can hear Lally a bit better. Thanks to the court reporter for saving the day.
accepted as a mistake. There were numerous offers
heroes.
by the Commonwealth to offer a stipulation as to the truth as far as the evidence.
A stipulation's not sufficient, Lally. All right, I'm just
Acknowledged,
backing up that argument.
and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the...
So, this is why Brendan should be arguing this. Lally is trying to argue it, and Lally's just like, statements?
Question from counsel was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi. Okay.
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for
They're probably almost
scheduling.
done.
The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45.
What?
Ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch,
I'm
you're
happy
free to
with that.
stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
We have no objection to that. One request we have, Judge, is during the last trial, during the deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes away.
I'm sure we can make accommodations for that.
Okay.
But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right. So we'll see counsel in
Oh,
here
and
no
we're
later than
done.
8:30 tomorrow morning.
Sure.
We'll counsel here at 8:30. All right. Thank you.
All rise to the court, please.
I get it. Okay.
Well, that was stressful and unexpected. Hi, everybody. Thanks for waiting. That was not what we needed. That was not what we needed to have happen. All of you are saying the wrong mic. I'm not surprised by that. Give me 1 second. That shocks me none. Because what? Because why? Oh, I was trying to get back online so fast that I am not surprised that we have the wrong mic. I'm gonna have to restart this real quick. But I did want to let you know that I was back. So we're gonna have to deal with shit audio for... And then the microphone should be back. So it's restarting. Everything just went wild and we lost the internet. So don't worry. We'll be back once my microphone starts back up, because apparently that went down when I had to restart literally everything. It's not the weather. I have no idea what it is. I don't know where Dr. B is. I put out the call. I have no idea where he is. So that's not ideal either. That's not super helpful. I have no idea where he is. So it's all the things, but the internet is completely down. It had nothing to do with weather. I have no idea if it has to do with construction. I don't know. So I had to go to backup device. All right. Our microphone should be back, but I had to go to our backup internet that I use when I travel. But it was still in my travel bag. It's a whole thing. It's a whole thing. Remember yesterday when I said everybody were too hard on ourselves? At least it wasn't during closings. The way I would have lost my mind. And now we've got the backup internet back and it's going to be fine. So it's just going to be fine. And we have an app so we could let everybody know. We're going to answer questions. Look, let's try to do a summary of what happened today before the internet just yeeted me off of everything. Because remember that was delightful. Ugh. I hate it so much. We'll fix it in post. Let's try to talk about what just happened in these conferences. Let me make sure I've got chat back up real quick. I came back before we did any of those tests because I wanted to, well, A, come back and let you know I was here, and B, we've got a lot of really interesting stuff to talk about. Like a lot of it, a lot of questions. And I said, no, we'll get to these questions. And then the internet just went, and all of you, I'm sure, went, no, wait, we have questions. We have so many questions. So let's do our best to summarize what happened in the charge conference today, because a charge conference is just that. It's discussion of what the jury will be charged with, often referred to as a jury instruction conference, depending on what jurisdiction you're in. But the jury gets their jury charge. That is the word that is used in particularly more formal courts. They are charged with the duty of rendering a verdict, and the instructions are how they do that. So going through what the instructions will be, how they will be edited, it's incredibly important for the lawyers and to know how it's going to go. And we heard that controversial instruction discussed by the court, didn't we? When the court was talking about the multiple indictments, and the court said that I think that instruction's pretty clear, and the Supreme Judicial Court agreed with me. So I don't know if we will see more about that particular instruction discussed, but we will hear it tomorrow. We also know that the court is going to give, hold on 1 second. Miguelina, will you just go a little bit longer on subscriber mode so we can cut down on the bots? Thank you. It is a whole thing. I just want to make the mod's life a little bit easier. Everybody who wants to be here and chat about the case has been subscribed for a longer period of time. So I would very much appreciate that. Thank you so much. Just to cut down on we're getting towards the end of trial, and I don't want the mods to just be overrun. We've been seeing in the comments too. So we've been on subscriber mode. We're always on subscriber only mode, but we want to encourage people to come in and chat. And so if they're new subscribers, they can come in and chat. But at the end of cases, especially as we end up different places on live trending, we end up with either bots like we get in the comments after every single live, and we also get just the standard trolling you expect to see on the internet. But it happens especially as the streams get larger. But we don't want to discourage new law nerds who are like, I'm so glad I found this community. So it's always a balance. But at the end of a trial, I just don't have the patience for it. I don't. I'm just like, we're just kick first, ask questions later at this point. So we're not going to get trolled on people who want to come in and stir up shit in the chat either. It's just why we're here to have a conversation. So that's what we're doing. Okay, let's continue. I know. Let's continue with what we were talking about happened at the charging conference. Things that were curious to me. The Commonwealth is not asking for any lesser included charges. That only goes to count 2. We will talk about the counts again, especially as we hear the jury instructions. Count 2 is the vehicular manslaughter count with the DUI, and it has lesser includeds. The defense is asking for those lesser includeds. A number of you in the chat said that the prosecution did not ask for those lesser includeds last trial either. What's interesting is that the court can give them even if the Commonwealth's not asking for them. That's not true in all jurisdictions. In some jurisdictions, if the prosecution says this is the charge, no lesser includeds, then they don't get given. Some of you are asking, what is a lesser included? With some crimes, you have the charged crime, and there are other crimes that are a part of it. So when you have a charged, well, we can talk about the ones that were in the case last time, but when you have a charged vehicular with DUI, a lesser included can be just a plain DUI or just a plain involuntary manslaughter. They are charges that are all accounted for in the primary charge, but they are less serious charges. So those are the lesser included charges that are all necessarily included in that main charge. So you could, in theory, have a murder charge and then have a lesser included of an assault, because the same action would need to happen. The murder charge would be that someone died. That's probably a bad example. It would probably be an attempted murder, and an assault is a better example. So if they don't find the intent for like an attempted murder, then you could have the assault as a lesser included of attempted murder because you've caused some harm, but you might not have intended that that harm kill someone. So with regard to just count 2, there are lesser includeds. The defense asked for them. Those will be included. I got a lot of questions. Why would the defense ask for lesser includeds? Well, it gives the jury room to compromise. And when you've seen jurors talk from the first trial, they had more leaning towards guilt on count 2 in the first trial, and the defense might want to give the jury somewhere to go, especially with the amount of statements that came in for Karen Reed. A jury might not sit well with nothing. You give the jury room to compromise so that if jurors are like, okay, I'm definitely out on count 1 and 3, I'm not sure about count 2, but can we really say that it's more than a DUI or more than a lower level involuntary? It gives the jury room to compromise. But sometimes that's why prosecutions don't want, or prosecutors don't want lesser includeds, because it gives room to compromise. Sometimes the prosecutors are like, it's this charge or it's nothing. Decide. We're not giving you more options. But the defense is asking for those lesser includeds, and so the judge is going to give them. The defense also proposed a different verdict form than we saw used last trial. The defense argued over that verdict form last trial, saying that it was confusing, and then they have asked for a different verdict form. The court might not give it because the verdict form that they used is the standard verdict form. What's the remedy for that? Well, the attorneys have to then spend time talking about the verdict form during closing arguments. And the court gave them closing argument. Excuse me. And the court gave them an extra 15 minutes for closing arguments. I wonder if tomorrow we will see the court giving a little bit more on that, but Lord, 15 extra minutes. Okay, sure. Great, 15 extra minutes. But that is what the court said. And then the thing I was interested in hearing was the argument over the missing witness or necessary witness instruction, and the defense withdrew it. So they're not asking for it anymore. So we're not going to see a necessary witness instruction. The defense is no longer asking for it. And the court is deciding if there will be a more stringent or pointed special instruction on the issue regarding John O'Keefe's hoodie. Mr. Alessi asked again for the court to give a more thorough instruction about the questions that were asked from Dr. Wolf. The Commonwealth said, look, an instruction was given at the time. That's sufficient. We're asking that no further instruction be given during closing argument. The court's going to decide on that, and we will see tomorrow. The court has indicated that she wanted the court staff to call the jurors and see if they could come in early. She wants butts in seats by 8:45 tomorrow morning to start closing arguments promptly at 9 a.m. The court has indicated that they will do closing arguments, which means the prosecution will go, then the defense, then the prosecution with their rebuttal at the end. Then there will be an early lunch. Then the court will do the final charging, which will take about an hour to read. She wants the jury to deliberate. The court also said, and this surprised me, she is asking the jury if they are willing to stay till 5 or 5:30 so they have time to deliberate tomorrow. The court wants to give the jury time to deliberate. And if they start at 9 and each side gets an hour and 15 minutes, that's 2.5 hours. So that will take them till noon. If they take a 30-minute lunch and then the judge reads instructions, they might have the case to start deliberating around 2 in the afternoon. And so from 2 to 5 would give them more time to deliberate before they go into the weekend. The court said she did not want to just have argument, charge the jury, and then send them home for the weekend. So we will see the jury getting some time to deliberate tomorrow. Will it be enough time? I don't know. I don't know if it will be enough time, but we will see. So the evidence is done. The parties have rested. The jury instructions are being edited, and closing arguments will be Friday morning, starting, the court says, promptly at 9 a.m. We will see. We will see. So let's get into your question. I know you have a lot of them. There are other things I need to pull up as we get to Q&A, so do not worry. We will get there. Let's go ahead and swoop to questions, because you've got questions, I've got questions, we've got questions. We're just going to swoop to questions today because today has been so much. Emily, did you leave it on loop? Yeah, I forgot that was on. Also, for all of you saying, so you're telling me, Emily, you're sitting here telling me that this case started on April 1st and is ending on Friday the 13th? Yes. 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 How long the jury will deliberate is up to them. But yes, that's exactly what it is. That's exactly what it is. So let's answer your questions. Miguelina, can we put up a pinned comment that the and it was just a full moon, that the court is done for the day and we are answering questions because court is done for the day. Also, when we edit this, I'm optimistic that when we edit out the gap, we won't lose the live chat, but we might. So we'll timestamp it and then we'll edit it tomorrow or down the road, but we'll timestamp it so you guys can jump forward. But yes, we started April 1st. We're ending on a Friday the 13th. I don't know if the lawyers are superstitious, but maybe they're just a little stitious. Who knows? So let's answer your question. First question that I saw a lot of you ask about. If there is a verdict and I am not streaming, how will you know? The Law Nerd app is how we are going to tell you. I will try to alert you on YouTube as well. Sometimes you get those notifications, sometimes you don't. I have been told by the head of the YouTube algorithm that algorithm is based very much on the individual viewer. So if you have, all notifications turned on your YouTube for 10 channels and all 10 channels put out a video that day and you got those notifications, you might not get any more notifications for the day at all. If you have notifications on for one channel, but you receive notifications the day before, you might not get them. It is, the algorithm balances when they notify you. So we don't necessarily know how that will work. So we will try to notify you here, but we will notify you in the Law Nerd app. It is a free app at lawnerdapp.com. I have been told it was a little slow today. We are 100% already into people in the email about that. Don't you worry, because we are getting into verdict watch, and what we can't do is have things be slow. So we are getting into verdict watch. A number of you have asked, is the jury going to deliberate over the weekend? No, they're not. The jury does not deliberate over the weekend. When they are sent home for the weekend, they are home for the weekend. Let's see. Kayla asked, did the defense get their PowerPoint in? No, the court kept it out because there was objections. So it is not in. Brent Woodchick and everyone who gifted memberships, thank you. We are going to do a members only today if my internet holds and the power holds. So fingers crossed. I am setting that for 3 p.m. Central. So it is almost noon here. So in about 3 hours, we will do that. I do have a hard stop this evening, but we will be doing that. So let's see. It's always time for questions. I mean, we have questions about Randy. We have questions about all the things. Jen said that her daughter is getting married tomorrow on closing argument day, Jen, on Friday the 13th. I love it. I hope it is a beautiful day. The weather cooperates and the music is good and the food is delicious and the drinks are plentiful. Rachel said, my last day before vacation, we will miss you. I mean, tomorrow's a day. Tomorrow's a day for that. My honey, I have seen a couple issues on YouTube today. I have no idea what's happening. Dawn, the sleepless hag, said, asked at 2 cranial MRIs. We talked about this maybe a week ago, where Dawn was saying, oh, I've got cranial MRIs coming up. I'm going to ask about my occiput boner. The first looked at me like I had 3 heads. The second MRI, she laughed. My occiput boner is fine, but they saw a mass EDB helping me be sane. Good luck. And I'm glad they are on top of it. Also, I'm glad you got to joke with your MRI techs about the occiput boner, because anyone in medicine is going to be like, what the fuck did you just say? What? Like, what? J. Michael, good to see you, said, have to give it to Kanoni. She is truly paying attention if she corrects like that. And I'm torn on her still. She does pay close attention. She does pay close attention. I don't always agree with how she rules on things, but she is paying attention to this case. And she very much remembers what is said in her courtroom. Emily Jade says hi again. And Heather, can't wait for Disney Day. Good to see you. Hi, Jade. It's good to see you too. Claudio said, who is talking? I've never seen him. That's Attorney Lally. Attorney Lally was the lead prosecutor last trial. He questioned 3 witnesses, maybe 4 this trial, some of the scientific witnesses. Alex said, no evidence of a dog or absence thereof. Woof. Yep. Attorney Lally argued that too and said there is no evidence that there was a dog at the house or absence of a dog from the house or absence from a dog after the house. There is evidence that the dog moved to Vermont and changed its name, though. So there's that. There's that. Cleo's mom, I think this is a good question, and I wanted to make sure that I cleared this up. Cleo's mom said, EDB, if everything is skewed to the light most favorable to the prosecution, how is any defendant getting a fair trial? It's for the motion to dismiss. And when we talk about motions to dismiss in civil, and we talk about motions to dismiss particularly like a straight up 12B6, things are taken in the light most favorable to the non-moving party. So in civil, you don't have prosecution and defense, so it's easier to say non-moving party. The party that's asking to dismiss something, the other side of that, everything's taken in the light most favorable to them. So if there's 2 ways to interpret a fact, it's taken in favor of the other party. That is for the motion to dismiss only. At the motion to dismiss stage, if there's 2 interpretations of a piece of evidence, it is given to the prosecution on that motion. So to get a motion to dismiss granted, there has to be no evidence of a thing. No evidence that can be interpreted that way, no circumstantial evidence, just no evidence of a thing, which is why it's incredibly rare that they get granted. Because oftentimes if you have a case that's in that posture, it wouldn't go to trial. Because if there's no evidence of a thing, it shouldn't go to trial. But things happen mid-trial and people don't show up. So you never know that maybe an element doesn't get proven. But the court looks at the evidence for that motion only is if a jury believed all of the prosecution's witnesses in a generous way and didn't believe any of the defense witnesses, are the elements of a crime found? That's all that motion means. So hopefully that's helpful. My brain has put the words in the wrong place. I'm going to go with muffuggin or muffin, one of the two. Instead of gaining up, consider using compression. There are compressor browser extensions you can easily get. It will normalize the audio levels. We have a whole new streaming system in the works, but this is a great help. Thank you. We are working on it. Part of the issue with the court audio is there are times that I find that the pool camera, if the mics aren't on in court, they will gain it up on their end before they push it out, and then I can't level it well. Music to my soul said, Emily, stop. Why would they withdraw the motion for missing witness instruction? How does that benefit the defense? We're going to look at their missing witness instruction altogether, or we're going to look at their motion in a minute to get there. Kat Williams said, I know it's not a popular opinion, but I miss Lally. Kat, I think there's probably more in the chat that miss Lally after watching Brennan for a whole trial than you would assume. Lally had his flaws as an attorney, but Brennan has a different level of off-putting snark. So I think there are probably many that also were like, in hindsight, I will take Lally and his questions that have 17 sentences in them and his kind of monotone affect over Brennan's snark. So that's fair. Caitlin's going to the Old Dominion concert after closings. Congratulations and enjoy. Live music is good for the soul. Merzelina, congratulations. Rushing to finish report cards. Thanks for helping. Good luck. And I hope they're done by tomorrow. So you have a full day for closing, and thank you for the work you do. Crafticator said, I got married on 10/13. I think it's a lucky date. A lot of people lean into 13 for the luck. So I'm not worried about that. Crazy Asian 303 said, 10 million years later, pickle cleanse. We need to do that before the end of the day today. We will have lots of story times on members only later today. So everyone who got gifted memberships, don't forget that we are doing that later today. Closing on Friday the 13th is wild. It's wild. Natasha said, realistically, do you personally think we will have a verdict by tomorrow at 5 p.m.? I hate to lawyer answer this, Natasha. It's going to depend when the jury gets the case. If the jury gets the case at 4 p.m., no. If the jury gets the case closer to 1:30 or 2, maybe. It really depends on when the jury gets the case and how organized the closing arguments are. I think where the jury is going to get stuck is counts 1 and 2 are easier to discuss, right? On counts 1 and 2, and we'll go through the counts. Let me just pull them up real quick. Let me see if everything got shut down. So all of the pre-work prep I had done to make things go smooth is just kind of like, just right out the window. So I am doing my best to get all my drives back up so I can grab those. Oh, good. We've got to log back into accounts. That's helpful. That's super helpful. Let's pull up the counts real quick and go through them. And then we will go through the verdict form. And then I will keep answering questions about the defense's withdrawal of, I was going to say withdrawer. The defense's withdrawal of their request for the missing verdict. Hopefully that sounds fine. Magdalena, will you just put bullet points of what I said I was going to cover? We're going to do the counts, and then we're going to do the missing witness withdrawal. I will forget because my notes were up and now they're not. Let's pull up the indictment, and we're going to go straight from the indictment first, and then we will go to the count 2 verdict slip that was used last trial. It is not the one for this trial necessarily. It's the one from last trial. I also had all the jury instructions pulled up, and now they are all gone. Isn't that a delight? Yay for me. Streaming is dynamic, and I love being here with y'all. So we'll take the hiccups to make everything else work. All right, no, we don't. Can we stop trying to summarize everything? What is happening? All right. Commonwealth of Massachusetts, this is count 1. Oh, hey, Dr. B. I will have to talk to you about it later. I don't need help with the occiput boner. I called, I texted, I yelled, I hollered. I couldn't find you. I yelled outside. I yelled outside a lot. The internet went down. Can you call our internet provider and see why it's down? I am using my backup. And then if you check your phone, you have 77,000 text messages. You don't have your Apple Watch on, do you? You don't have your phone with you, do you? Mm-hmm. Thanks, hon. Did y'all kick over the internet line? Phone. Take your phone. Can you go find the internet providers and ask them what the fuck? Direct quote from me, what the fuck? Yes, I was looking for my husband. I was like, help! Help! I couldn't find him. I have no idea where he was. No Apple Watch, no phone. No, he's like, no. Yeah, Dr. B has no screen time. He's like, what? There's nothing urgent. Until there is. We got it up and running again. It would have been easier. He's like, it's fine. Somebody kicked over the internet. Please find out what's going on with the internet. Count 1. This is the second-degree murder. The second-degree murder says did assault and beat. That is the charge of murder. With the intent to murder such person and by such assault and battery did kill and murder said John O'Keefe and is guilty of murder in the second degree and not in the first degree in violation of the code. So assault and or battery, we're not going to get into the difference of assault and battery. This is much debated in law school. We don't need to get into the difference. If there is no hit with the car, then this can't happen. Also, there needs to be intent. So they are going to go through the jury instruction that includes intent. So on count 1, the first question the jury has to ask really is, did John O'Keefe die? Did the car cause him to die? And was Karen Reed driving the car? And did she intend for that to happen? Those are the things roughly that the jury has to find with a count 2. Was it intentional? Was she driving? Did that cause the death? I think for the jury, it's easy to look at counts 1 and 3 together and talk about intent. Talking about intent matters. It's something I think we're going to see the defense talk about a lot. We're going to see the Commonwealth say, but listen to what she says. But if the jury decides immediately that there's no intent, then there cannot be a count 1. There cannot be a count 3. We're going to skip ahead to count 3. It's got a whole bunch of elements that aren't going to matter because it's operating a motor vehicle. I think that's been proven. On a public road, that's been proven. Where other people can drive, it's not a private road, fine. Without stopping and giving all of your information to go away to avoid prosecution. So a hit and run causing death. Was Karen Reed driving on a road? All of those elements, fine, those are all proven. Did Karen Reed know that she hit something? Did she choose to leave to avoid prosecution? And did those injuries result in the death of John O'Keefe? Those injuries being the head injury, and there's also an argument that the leaving him outside can fall into this count. But you still have to have knowledge. Did she knowingly hit someone? And I think we're going to see the defense argue that her statements are, could this have happened? Could I have hit him? And that all of those statements are because she did not know. My music was blaring. Could he have tapped on the window? Could I have hit his knee? Could I have incapacitated him? Could. The Commonwealth is going to say that's her covering, that she knew she hit him and she chose to leave. She knew he was there. And I think the statement they're going to use to argue this is, he was where I left him. Now, I think the defense has an argument to say where she dropped him off to go to the party, not where she left him injured. We are going to see argument over her statements as to this count. This count requires intent and knowing. Did she know that she hit him and choose to leave? Knowledge and intent. That's count 3. So if the jury discusses this by intent, we get through count 1 and 3 more quickly. If they think there's intent, then they're not going to really fuss over count 2 all that much, because count 2 is lesser than that. If the jury says, yes, she hit him, yes, he was killed by a car, yes, there was intent, count 3 is not, or count 2 is not much of a discussion. If the jury doesn't find intent on these 2, then even if they find a collision, they don't have counts 1 and 3. There has to be intent and knowing. Then we get to count 2. Count 2 also has lesser includeds. The defense is requesting those lesser includeds. Count 2, did operate a motor vehicle? Yes. Hi, Dr. B.
Please finish what you're doing.
Okay, I'll be done in about an hour.
No, we need to reboot.
Okay. I know you don't know how to reboot it. It's fine. I'll do it when I'm done. Thank you. Appreciate it.
It is out in the entire neighborhood.
It's out in the entire neighborhood, right? Rebooting it's not going to help them.
People rebooted and it came back.
That's annoying. Did anyone say why it happened?
No. There was no.
Can we ask that question? Can we please ask them what the fuck? Were people cutting the trees again? What happened? I know the entire neighborhood went out. I'm sure everybody collectively went, ah! Let's talk about count 2. Count 2. Did operate a motor vehicle? Yes. Is it on a public street? Yes. Can people access the street? Yes. So was Karen Reed driving? Was Karen Reed intoxicated? I think the jury can find on the evidence that she was intoxicated and that her BAC was over 0.08 based on her own statements. But then you have Karina Kolakithis, who I found to be a very credible witness, saying she didn't seem intoxicated to me. I think there's enough evidence for the jury to find that she was driving drunk. And I know immediately what all of you are going to say. Yes, but everyone was driving drunk. Yes, but that's not mitigation. LB, this is fair. It probably was the zebra. The zebra's like, I want the internet. I think the zebra's back home. But yes, it might have been Ed the zebra. So I think there's enough evidence for them to get to a DUI. The argument that everybody was driving drunk doesn't negate the fact that Karen Reed was driving drunk and is charged in part with driving drunk. It's the next part, right? I think there's enough there for them to prove a DUI. Okay, why didn't they choose to ever just charge her with a DUI? Because that's not what they chose to do. Could they have done that? Sure, they could have. Did they? No. Would they have had a BAC for Karen Reed if there hadn't been a hold for her? No, there wouldn't. They never would have taken her blood. They didn't take her blood because of a DUI investigation. That might matter to the jury. It might matter. They've had less evidence that everybody was intoxicated and driving than they did in the last trial, but it might very well matter to a younger jury that she was put on a psych hold and then they took her blood and then they turned around and used it against her. It wouldn't surprise me if that offended the senses of some of the jurors. I know that in the chat, a lot of you are like, this isn't right. And jurors can say, no, I don't like that at all. I don't like it at all that they were taking that blood for another purpose and then tested it so far later for alcohol and then worked it back. But you also have her saying, I was more intoxicated than I was not sober in her statements. And the statement, I'm trying to remember the statements that were put in versus the ones that I saw that weren't in evidence. But she talks about driving more slowly and driving more carefully than she would have. So you also have her own words saying, I was under the influence, but I wasn't like sloshed. I was driving carefully. So I think there's evidence for the jury to find it. The jury might also discount it and be like, nah, I think that's bullshit. A jury can do that. A jury can say, I 100 think that's bullshit. 100 think that's bullshit. That's up to them. So if the jury doesn't like it, the jury can decide on that. I think there's evidence there. We'll move on. Then the next part of this is where the jury instructions will get complicated. While driving under the influence, operated the vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described, did cause the death of another person. This is where I think the attorney argument is going to matter. Was their behavior that was wanton and reckless that might endanger the public and caused the death of another person? And I think we're going to see and hear from Brennan that she clipped him and caused him to go backwards. I think that's what we're going to hear. I believe we will hear Brennan say, I didn't hit him, because those are Karen Reed's words, but clipped him and caused him to go backwards. I think there's argument to that on the other side, but I think that's what Brennan will argue to this. I think we'll also see Brennan argue that the pedal was down or the acceleration was at 74%, the throttle was at 74% open, and the speed backwards was so high that the speeding backwards while intoxicated in this weather conditions late at night is wanton and reckless conduct. And that caused the death of John O'Keefe. If the jury does not believe that John O'Keefe was contacted by the car, I think it's harder for them to find count 2. But as we get into the lesser includeds of count 2, if the jury finds that John O'Keefe was trying to get out of the way of the car, could they interpret some of those other counts as Karen Reed being a substantial factor in John O'Keefe's death? Maybe. I think that comes down to argument of the lawyers. And that's why I think we're going to see the defense zeroing in on there's no collision. There's no collision. And all the experts told you there's no collision. And I think we'll see the defense talk about Dr. Wolf hungry like saying this can come from slipping backwards. And the defense arguing. So John O'Keefe got out of Karen Reed's car, went to go to the home, and it could just be that he slipped, went backwards, hit his head on the berm enough, and then stayed there, and no one saw him. We might see the defense argue that. We might see them argue he could have gone into the house and slipped before anyone knew he was there. There's a whole lot of questions subsequent to that about how he ends up back out in the snow, but the defense are going to talk about the 38 steps. And the prosecution's going to say, you heard her say the music was blaring. There's no lights in that area of the yard. It's over by the flagpole. And I think in this trial, we heard that John O'Keefe's head was oriented closer to the road, not closer to the house. So we'll see if they argue that. So the argument on count 2 does not require knowing intentional conduct. It requires reckless driving conduct. And the prosecution's going to argue the speed, the distance traveled backwards, the amount of gunning it backwards, the intoxication, all of those things fall into that conduct. And that's why we're going to see the jury hearing from the defense. If there's no collision, then there's no responsibility. Then you get into the lesser includeds of this count. I don't know if they're going to put in a straight DUI and give the jury the option to just find a misdemeanor DUI. I don't know. I can understand the defense arguing for that. Let's look at what the jury instruction said last time, because there are lesser includeds of count 2 that are not as serious and not as severe of a charge. This is I don't even know what they title it. Let's get to the jury instruction and we'll see what they title it, because off the top of my mind, I have forgotten. But the way the lesser includeds were shown last time and the way they will be shown this time, I think it will be clear to the jury which are less serious. Jurors can figure that out, right? You put them in order of this is the top one, then this, and this, and this. They can figure out for themselves, oh, that means these are less serious. Jurors are not unintelligent. They can figure out the top one being first means it's more serious. Let's look at those jury instructions together. And let me try to do this. So nope, that's harder to read. That's better to read. This is the verdict slip that was used last trial for count 2. The defense is arguing that they need an easier and more clear verdict slip. This verdict slip says, in the above entitled case, here's the first count, offense 2, manslaughter while operating a motor vehicle under the influence. In the above entitled case, we, the jury, say the defendant is 1, not guilty, 2, guilty of offenses charged. That's the top one. Nope, I did that terribly. Guilty of the lesser included offense, guilty of the lesser included charge. Sorry, that's me. It got squirrely. The defense was arguing it was unclear whether or not the not guilty modified all of the charges. The prosecution said last time, look, if the jury finds her not guilty, that top one says not guilty. But can you understand a jury saying, okay, this not guilty, number 1, goes to charge up here at the top. So what if they hit not guilty on number 1 and then guilty on number 4? Right. And it doesn't say we find the Karen Reed not guilty of manslaughter while operating a motor vehicle or guilty of manslaughter while operating a vehicle. If you find not guilty, and this is what they do in California, if you find not guilty, please continue to consider the lesser includeds and then put lesser included, guilty, not guilty, lesser included, guilty, not guilty, and let them walk through the jury instruction. So is it not guilty of charge 2 or guilty? If not guilty, then consider the lesser includeds and then put not guilty, guilty, not guilty, guilty. The way that the court interprets this form as the not guilty goes to all 3. So the top one is not guilty, and then you decide if she's guilty of others. This is how it's standard in Massachusetts. I don't know if the court will change this. What I prefer, like my preference matters, but I prefer the instruction saying, if you find the defendant not guilty on charge A, and I would prefer these lettered, then consider if the defendant is guilty or not guilty of charge B. If you find the defendant not guilty of charge B, then consider if the defendant is guilty of charge C. And it spells it out. But the lawyers need to pull this up in closing and explain it if this is the form that they're given. Because I can see the confusion 100%. And I like very much when it says, start here, if not guilty, then go down. If not guilty, then go down. We'll see what happens. The lawyers can say that to the jurors. And in the instructions, it does tell them to follow that order. But the instructions are an hour of like, wah, 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 wah. So, 2 in this, I wish it was like A, B, C. But 2 in this is the manslaughter while operating the motor vehicle. And then they have to pick. Is it while under the influences of alcohol or is it 0.08 or greater? So they have to decide if it's been proven that she was under the influence or if her BAC at the time of driving was above a 0.08. Then they have to decide the involuntary manslaughter. If they find not guilty on the involuntary manslaughter, then they have to decide the motor vehicle homicide. And then if they decide the motor vehicle homicide, then they have to decide if it's operating under the influence or over 0.08 or both. And what I think is confusing is that I think some may look at this and say, well, motor vehicle homicide sounds really serious. Is manslaughter less serious? Is it more serious? If you're just reading the jury instructions for the first time, does homicide sound worse than manslaughter? Does that seem more serious? Because in these, motor vehicle homicide is the least serious offense of all 3 of those. And the involuntary manslaughter maybe sounds like it's the least serious one. So if the jury is trying to say, you know, I think she did something, but also I don't think she should be in prison forever, if they are trying to figure out which one's the least serious, I think this can also be confusing. But the attorneys need to argue it. So we will see exactly what lesser includeds are there. I think that the defense has asked for a DUI. I heard them mention it today. And so there might also be another one that says DUI. So we'll see. And a lot of you are saying homicide sounds more serious than manslaughter. Right. I get that. I absolutely get that. Because it's part of our, like, I don't want to say popular culture, but it's part of our cultural vernacular that we use the word homicide to talk about murder. And we don't spend a lot of time differentiating between manslaughter and homicide. And different jurisdictions have different codes for homicide versus manslaughter. And so, I get it. I get it. And a lot of music that references crimes tends to reference back to West Coast charging. And what California does, you hear things like 187, that's a California code, though I do think every jurisdiction should just change all their codes to fit that, because in my brain, Emily, is this about you? No, but yes, because 187 just stands for murder, and that's what makes sense in my brain, because that's what, we grew up in the 90s listening to music, and because that's the code for murder in California. There are people who know the criminal codes in California more than they know the criminal codes where they live. 187 is murder, 211 is robbery, 5150 is a psych hold. These are not the same codes that are everywhere. Emily, could you keep going? Yes, but I'm not going to rattle off the entirety of the California Penal Code for you. Though I could. Everybody's like, yeah, Snoop Dogg, 187, exactly. Snoop Dogg's from the LBC in Compton. So when we get into count 2, we will see them arguing about the way that the not guilty is put at the top. I think the court says that this indicates the jury can find not guilty first and not guilty of everything. I understand the defense saying, but we think each individual one should have a not guilty in it. I get it. I get it. I get it. I get it. We also have, I think there's a potential for confusion between involuntary manslaughter, motor vehicle homicide, and manslaughter while operating a motor vehicle under the influence. They go most serious to least serious. If you are ever in doubt, courts do not order them to confuse you. If you are ever on a jury and you see things in order, the bottom one is the least serious. Every single time. If a DUI is in here, then a DUI will be added to the bottom. They do not scramble them. It would be improper and potentially misconduct and prejudicial to do it. Here's the reason the court might be hesitant to change this form. These are the standard forms. Messing with jury instructions and the standard forms that have been approved by the Supreme Court of the state is one of the things that will cause something to get overturned on appeal faster than anything else. Fucking up the jury instructions is one of those do not pass go issues on appeal. Changing what the form is can create a problem. My counter argument to that: the defense is requesting it. So if the defense goes to appeal that the jury form that they proposed was confusing, the appellate court is going to look at them and say, you wanted this one. You did not object to it. We gave you what you asked for. Therefore, there was no objection on the record to this form. Therefore, you cannot appeal on that issue. If I am a judge and all things are considered the same, I give the defense the form that they want, even if it doesn't match the standard form, because it removes the appeal issue on that question. You sometimes be careful what you ask for, but you asked for it, fine. Fine. But courts are very hesitant to change the standard forms. And when you look at jury instructions, they have standard forms. Not talking about count 2 last trial. They didn't talk about it at all. Not talking about this count caused a tremendous amount of confusion. And the jury instructions on this count are fucking confusing. They need to be explained. It would take 45 minutes of a closing to explain all these lesser includeds. What does reckless mean? What does wanton mean? What does without intent mean? What do all these things mean? What does it mean and or? Under the influence. What does under the influence mean? What does 0.08 mean? What do all these things mean? Why are there 3 of them? It's confusing. I agree that it's confusing. They are going to hear jury instructions, and tomorrow when the judge reads the jury instructions, I am going to pause and highlight when the court gets to this part, and I am going to let everyone know, don't turn out. Come on back. These are the instructions for the charge. Come on back. Listen to these, because the court's going to read all the instructions for manslaughter while operating, then involve, then motor vehicle homicide. And they are difficult. Do you want to take a look at those jury instructions real quick? Let's see what time it is. Before we move on to talking about the withdrawal of the missing witness, do you want to look at the withdrawal? Yes, yes, yes. Okay. I see you, chat. All of you are like, yes, please. Perfect. We will. I think count 2 is something all the attorneys are focused on. At least the defense is. I think the defense needs to be focused on count 2, because what the defense doesn't want is the jury to compromise verdict on manslaughter while operating a motor vehicle, because it still carries a pretty substantial sentence. The other one's not as much. But count 2 can carry a fairly substantial sentence. We'll talk about sentencing more tomorrow. So let us get into those jury instructions. Let me find them real quick because they're in multiple places. CM Laval said there was no BAC report. There was testimony of it. There was testimony and a retrograde extrapolation. The jury might not agree, but there that is in evidence. And the jury gets to decide how much weight to put on that. So I had all of these pulled up for us. And now we're doing it again. Let's see. What did we need to look at? Let's look at the ones I can pull up first. We're going to start with the lesser included of the motor vehicle homicide, because I can pull that up fastest. And, oh God, there's 7 of them. I don't know which one they're going to use is the problem. Well, let's start with the top one. Here, let me show you what I'm looking at. Ladies, gentlemen, law nerds, humans, once I was like, you guys to the jury, guys of the jury, you guys of the jury, very California of me. And the judge was like, Miss Baker, it is never you guys. It was very much, it's always yes, never yeah. I'm like, Your Honor, it is you guys. It's yous guys. Hey, you guys, this is what we're doing. We did not do that well. We did that moderately well. It's been a long day. We got lippy enough. Let me show you what I'm looking at. There would be days when Dr. B would like, are you almost home? I'm like, I'm editing jury instructions. And he's like, how long is that going to take? I'm like, who fucking knows? They can be very difficult to work with. We're looking at the criminal model jury instructions for Massachusetts. These are the revised from 2024. The revised from 2025 aren't out. They might have them. We're going to the motor vehicle OUI offenses. No, we're not. We don't need the OUI offenses because those are the lessers. Hold on. Back to the top. Back to the table of contents. Oh, motor vehicle and OUI offenses. Because OUI is different than the 0.08 in Massachusetts. And here's the thing. When we are looking at motor vehicle homicide, that's not nearly big enough. Let's see if I can change the layout on that just a little bit. Give me one sec, law nerds. There we go. That should work. When we look at these, they have to determine which version of the jury instructions they want. Do they want 5.140 motor vehicle homicide, felony, OUI, liquor, and recklessness? Do they want 5.142 OUI, drugs, and recklessness? No, that's not what they're arguing. Do they want 5.144 over 0.08 and recklessness? Do they want 5.146 OUI, liquor, and negligence? Do they want 5.148 drugs and negligence? No. 5.150 BAC and negligence. 5.156 felony and recklessness. Or do they want the misdemeanors and negligence and the misdemeanor OUI, liquor, the misdemeanor OUI, drugs? All of those are motor vehicle homicide through 5.166. All of those are motor vehicle homicide instructions. They have to pick which one they want. Right. Brian Finch in the chat. Yes, the Lawnerd app is available in the UK. It's in the iOS and Google App Store. So they have to pick which one they are going with. I'm going to read the top one. The one they may read in court tomorrow might vary. At least I'll hear the court read which instruction tomorrow, and then we'll know. We're going to look at the OUI, liquor, and recklessness. That is what was on the sheet last time. So that is what we were going with. Hear me. This may vary. Karen Sue said, when do they decide all this? They did it at the conference today. So the attorneys submit their proposals, and then if they all agree, the judge doesn't even talk about it. We don't have those because they weren't filed. If someone puts them online, let me know. I will be thrilled to see them. But they do that today at the charging conference. Jane asked, when are closing statements? Tomorrow morning. Motor vehicle homicide. We are reading this as an outline. Defendant is charged with motor vehicle homicide. That is the least lesser included. They need to prove these 5 things beyond a reasonable doubt. First, defendant operated a motor vehicle. Second, defendant did so. And then they have to pick which one it is. See everything in parentheses? They go through and they line out the ones they're not using. On a public way, in a place where the public has right of access, or in a place where members of the public have access as invitees or licensees. On a public way. Good. Third, while operating a motor vehicle, the defendant was under the influence of intoxicating liquor. Fourth, that while operating a motor vehicle, the defendant did so recklessly so. Well, that needs to be edited. That while operating a motor vehicle, the defendant did so recklessly so that the lives and or safety of the public might be endangered, and that the defendant's act or acts caused the death of another person. Do you see where the trouble lies? Right? So then they have to define what is reckless. I'm not going to go through the first elements. We know what operating a vehicle is. We know what driving on a street is. They're going to read these all to the jury. The Commonwealth must prove that they were under the influence. They will talk about that. They will probably add the 0.08 language in there. We're skipping it. Fourth element, the Commonwealth must prove beyond a reasonable doubt that the defendant drove recklessly in a manner that might have endangered the lives or safety of other people. They are going to argue speed, intoxication, backing, and weather, I think, on that. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or that they are indifferent to whether someone may be killed or seriously injured. The Commonwealth's going to use her words for this. Could he have walked behind me? Could he have backed up? I didn't even know he was there. Her music's blaring. She's zooming backwards. It's dark. It's snowing. It's all of those things. That's what they're going to argue. It is not enough for the Commonwealth to prove that the defendant acted negligently. That is, acted in a way that a reasonably careful person would not. Rather, it must be shown that the defendant's actions went beyond negligence and amounted to recklessness. This is why the speed matters. They're going to argue that the speed, given the weather and the intoxication, is the recklessness. And they're going to argue the percentage of acceleration, that 75%. That's what they are going to argue. The Lawrence at EDB, can the lawyers discuss the jury instructions anymore tomorrow or no, are they done? They're done. They might, if the court modifies them and then there's an issue, they might talk about it briefly, but they're not going to argue it more. Then the definition of recklessness, the defendant was reckless if they knew or should have known that such actions would pose a grave danger or death or serious injury to others, but they chose nevertheless to run the risk and drive in the manner that they did. They're going to argue that intoxication itself is part of this, and then the speed, etc. So they're going to use Karen's words on this. This is the least serious crime, but it does still have the option of some custody time, to the best of my memory. We'll talk about custody time tomorrow. I need to go through and pull them again. Some of them have mandatory minimums, some of them don't. And then it goes through defining reckless. In determining whether a defendant drove recklessly in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed, manner of operation, the defendant's physical condition, intoxication, and how well they could see or control their vehicle, the fact that the tires were already slipping, that it's snowing, the condition of the defendant's vehicle, the fact that there's a backup camera, perhaps, negates a little bit of that. The kind of road it was, who else was on the road, the time of day, the weather, the road conditions. These are the things the jury is going to be told. The defendant must have intended their acts in the sense that the acts were not accidental. Intended the acts means they must have chosen to drive in the way that they drove. That's what is needed. Not that they intended to hit someone, not that she knew John O'Keefe was there, but she intended to drive in the way that she drove. Not that the car took off on its own or something like that, right? So, it is not necessary that the defendant intended or foresaw the consequences of those acts. That's why I say they're going to use her words here. As long as a reasonable person would have known that the acts were so dangerous that death or serious injury to other people would probably result. That's why the prosecution harped on the speed and the throttle. 75% acceleration. That's a lot. The speed and speeding up. That's a lot. But you, on the other side, are going to have the defense arguing, look, you heard Dr. Rentschler say, once you determine John O'Keefe wasn't hit by a vehicle, there's nothing else to consider. So there's nothing else to consider. Period. So that's where those arguments are going to start to interplay. The Commonwealth didn't argue count 2 at all last trial. I wouldn't be surprised if they spend more time on it in this trial. So that is one of the lesser includeds. The 5th element is that the acts caused the death of another person, and that prong has 2 parts. The 5th element, or the 5th prong, we're going to go with 5th element. The 5th element has 2 parts itself. The Commonwealth must prove that the death would not have occurred but for the defendant. Karen Reed must have caused the death in some way. That's why we saw a fight over hypothermia. Did she leave him there when he was incapacitated and unable to get to the hospital? I think we'll see the Commonwealth argue this because they asked Dr. Wolf a lot about, well, what if he got treatment? Well, how long? Well, this and that. We heard it with Dr. Wolf. So we will see them argue about him staying in the snow. And the defense also was thinking of this because they brought in another doctor to say, no, there is no hypothermia. That is from resuscitative efforts. And we're going to hear those arguments, I think, from both. And then the second prong of that is that the Commonwealth must prove beyond a reasonable doubt that a reasonable person in the defendant's position would have foreseen that their conduct could result in serious injury or death. Do you know that rocketing your car backwards can cause serious injury or death? And is the argument to the other side of that, but if you have a backup camera that alerts you to somebody being back there, don't you know that you're going to be alerted if there's somebody behind you? So you can see where you now have For count two, you have 3 lesser includeds. It might be 4 tomorrow. You have 3 lesser includeds. Each of those lesser includeds have at least 4 to 5 elements, if not more. And some of those elements have subparts. So it's element 1, element 2, element 3, A, B, C, element 4, A and B, element 5, A and B. So when y'all are asking me, do I think there will be a verdict tomorrow? It depends on how much they talk about this count, because it's a lot of things to decide. If they have questions about count 2, they have 15 plus different elements to go through. It's a lot. If they're like, he wasn't hit by a car, there's no intention, we're done here, then it might be faster. But this is a lot to consider. So I also will say that I'm not going to read a lot into a verdict tomorrow or not tomorrow. Here's why. This jury has not been able to talk about the case for 8 weeks, and they're going to want to talk to each other a lot. And they might want the weekend to think about it. However, they might also be done. Insert name here said, Emily, can the jury take notes when instructions are explained? They can, but they'll be told that they will be given a copy of the instructions and to just listen. So they can, but they might. Gator Girl said, EDB, no lesser includeds. What does that mean for the charges? There will be lesser includeds because the defense is asking for them. So there will be. If the defense changes their mind, then there won't be. If there's no lesser includeds, then it is just the manslaughter while operating a motor vehicle, not the motor vehicle homicide and not the involuntary manslaughter. But they're asking for them. So I think we will see them. Let me see, because it took me forever to find yesterday. I'm going to see if I can find quickly the motor vehicle while the manslaughter while operating a motor vehicle count 2 jury instruction, because it's in a different set. So give me 1 second to try to find that. Let's see, what's the exact title of this section is also much. Manslaughter while operating. All right. Let me see if I can find it again. If I can't, we're going to move on and we'll do it tomorrow. I'm hoping I can find it quickly. Let's see. It's going to take me a moment. The charging on this one, though, the reason the defense is fighting on the manslaughter while operating, it's a 5-year mandatory minimum. And then I think it goes up to a potential of 20 years, but a 5-year mandatory minimum is a lot. That's a floor. Like that is a no questions asked, don't pass go. If you get convicted of count 2, it is 5 years in prison, period. And it can be more, but it cannot be less. And that's on count 2. So Ellen said, why would the defense want a lesser included? Because if they are worried about count 2, they may want to give the jury an option for compromise that is less than a 5-year minimum. Because a mandatory minimum means if you're convicted of this, prison starts at 5 years and goes up. So it's giving the jury options, because there will be some jurors that are like, she was drinking, she was driving, she was the last person there. She said in her interviews, he was where I left him. And so they might want to give the jury an option to find just a simple DUI, to find an invol. It just depends. And of course, all of that will be appealed if there are convictions. And if there are convictions, they will ask for a stay of sentence pending appeal, which, given that she's been out of court or out of custody this entire time, it wouldn't be unusual that that be granted. So if the defense is worried about her statements, it is a reason they would want those lesser includeds to give the jury somewhere to compromise, because they rather have her convicted of a DUI or a motor vehicle homicide than of a count that carries a 5-year mandatory minimum prison sentence. Let me see if I can find this jury instruction. Because again, it took a bit of time to find it yesterday, because it's in a completely different part of the jury instructions, because they have them all separated. Let's see. Which is why I had it all pulled up and then everything crashed. Hopefully this is it. No, this is motor vehicle homicide. I was so excited for a second. No, that's the easy one to find. I need the hard one to find, which is not happening. I will have to pull it up again. It took me quite a while to find it yesterday. I will have to pull it up again and go through those elements with you tomorrow. I apologize because I had it up. Let's see if I can find it. Oh, that's the verdict slip. That's the verdict slip. I was optimistic that I would be able to find it more quickly, but that's why I left it pulled up on my computer yesterday. We will go through it again. It does not require intent to harm or injure. It requires intent to do the driving, and the language is a bit stronger than in the motor vehicle homicide that we just went over, because the motor vehicle homicide is that lower standard. In relative order of those, the manslaughter while operating requires a higher standard. So let's see. Jessica H. said, why is she out of jail this entire time when other defendants are in jail for years awaiting conviction or not? Jessica, it is very different based on where you're arrested, what your arrest history is, what the charges are, if what the circumstances of the crime are, flight risk, etc. Like Donna Adelson. Donna Adelson is older than your typical criminal defendant. Donna Adelson has no criminal record. She is being charged not with the action of the crime, but with conspiracy to commit the crime in Florida. But Donna Adelson had herself a one-way ticket and was asking people for help figuring out how to get out of the country and what countries wouldn't extradite her back to the US. So she is sitting in custody waiting for trial because she is a flight risk. Karen Reed, not a flight risk, has bail, has indicated that she's not a flight risk, doesn't have any other charges against her. When she was originally arrested, it was a motor vehicle consideration. She has restrictions on drinking and driving, and they have determined she is not likely to harm anyone in the public. She is not a risk to herself or others. She is not likely to flee. So they go through the bail factors in the state and decide who gets bail, who doesn't get bail, how much bail they get. Prior criminal record plays into that, but also the type of crime. Like when you look at Darrell Brooks, ignore Darrell Brooks's lengthy criminal record. If Darrell Brooks in Waukesha had no criminal record and drove through a parade and was charged with as many homicides as he would, probably staying in custody regardless of his criminal history. There's other cases where you look at the case like a Corey Richins and you're like, is Corey Richins going to potentially be a harm to others? Probably not. She's accused of killing her husband, pretty specific type of a crime. But with Corey Richins, there's concern about witness tampering, there's concern about harm to self, and there's concern about flight. So there are different ways that they consider the individual, the level of the crime, and then each state has its own bail statutes. So it depends on all of those circumstances. Julie asked, did they revoke her license? I don't know for sure, but generally her license would be revoked for a minimum amount of time based on these charges anyway. So I don't know if she still has it or not. So, the Velvet Snark said, can you, I'm sorry, I almost read that very, very, the letters were moving. Emily, you've been streaming a lot. Yes. Can you remind us of the jury makeup? It's my understanding that this is a 50-50 equal split and a younger jury. That is the most I know, but we don't know what the final jury makeup is because there are still 6 alternates present and 6 jurors are going to come out. So we'll get there. Jamie said, Emily, thank you for pronouncing Waukesha correctly. I only learned because of that trial. And then when I drove past Waukesha the last time I was in Wisconsin, I'm like, I know a thing. So it's because I heard everyone in trial say it so well. So we will see which alternates are in and out tomorrow. Hopefully me highlighting one of the jury instructions for one of the crimes indicates how much the jury is going to have to go through and why these things may or may not take time. Because there's a lot. I'm interested to see what charges we get to in the lesser includeds tomorrow. So the thing with count 2 is that some of the language in the jury instructions says things like might cause injury, which I think can be confusing for a juror, says things like is a factor in John O'Keefe's death, and how the jury interprets factor. The defense is going to argue if John O'Keefe wasn't hit by the car, she's not a factor in his death, something else happened. But I can see a jury saying, well, she's saying, could I have clipped him? Could I have incapacitated him? He's where I left him. I can see some jurors saying she is a factor in this. So it's really going to depend. I think count 2 is where their bigger fight is. I think that the intent is an overreach. That is personally where I'm at. I think the intentional crime is an overreach. But we will see. Angela asked, Emily, do the 6 not deliberating have to remain sequestered? Yes, they do. I mean, not really sequestered. They remain away from the deliberating jury and they cannot talk about the case. I talked about that at the end of stream yesterday. So the 6 alternates have to wait until a verdict is rendered and still can't talk about the case. Hopefully they let them bring a fucking book. Like, let them bring a book. Let them bring a book. So, Judah said the OWI charge under lesser included. If they add in a flat DUI, it gives the jury somewhere to go. So if the jury is like, I'm not really sure, it gives the jury somewhere to go. Juries compromise on verdicts. It happens all the time. So we will see what the jury does. Though the jury might be so put off by this case that they're like, no, what are we doing? What are we doing? Will the alternates that are dismissed, can they talk right away? No. The alternates cannot do anything until a verdict is rendered, because if the alternates have to begin deliberations, deliberations start fresh. They have to stay at the courthouse. They have to wait. They have to wait. So, all right. Let us continue on. And then I want to get through the motion that was withdrawn because there were a lot of questions. Lauren asked, where do they go in the courthouse? Normally there is a separate jury holding room, but it really depends on the courthouse. So, yeah, so they would have to wait. Do alternates watch via stream or are they all on the bench? The jurors have to wait in the courthouse. They have to wait in the courthouse. And when the jury comes into the courtroom, the alternates normally come back into the courtroom if there's jury questions. It depends on the court, but they can't talk about the case. They have to wait. And they're not automatically dismissed. They have to wait because they might need to be tapped in. They're literally benched and they can't talk about the case until either a verdict is rendered or they get tapped in to go deliberate. So frustrating. It would be so, I talked about it yesterday. It would be the worst. It would be the worst. The worst. It's like, you've been here every single day of trial. Go sit on the bench and wait. We might need you. You're the alternate. I want to be in the room where it happens. Put me in, coach. Come on. It would suck. I can't even talk about it. It would suck. Is the charge conference streamed? Yes, I did that this morning. That's where we started today. I promised I was going to pull up that motion and then we're going to get to more. PJ said, Emily, please explain count 2 like I'm 5. I don't think I accomplished that. Count 2 doesn't require intention to harm, and it has a lot of lesser includeds that are confusing. And the attorneys are going to have to walk the jury through that, and I think it will be a loss if they don't. Rachel said, how do you think Hank and the Commonwealth is feeling at the end? Tired. tired. Lally's arguments were surprising. Like the way Lally sees the case and the way he argued is just hard for me to wrap my head around. Yeah, it's really hard to wrap my head around. We are going to be doing members only. I hope it's probably going to be like 3:15. I'm going to just need a little time to get ready. But yes, we're doing members only today. Polly says, done with evidence on my 45th birthday. Oh boy, happy birthday. More excited today than any other the day of trials. I don't know why. Well, because we learned more today. 3 years. Congratulations, Chrissy. Let's pull up that motion from the defense and talk about it real quick, even though it was withdrawn, because A, there's a lot of questions and curiosity, and B, it's helpful. Cameron said, are the alternates separated from each other? Normally they're together, but they can't talk about the case. Shell said, do you think some jurors talk anyway? No. Everyone I've ever talked to that's been a juror, every jury I've ever interacted with, and in California, that's a really normal thing that after the trial, you talk to the jurors. Jurors take it incredibly seriously. They take it incredibly seriously. And once they are in on 8 weeks of a murder trial, that they know that they are trying to figure out justice for the victim and the right result for the defendant, the just result for the defendant, they take it very seriously because it feels, I think, to a lot of jurors like you have multiple people's lives in your hands, the defendant and the victim. And that's not a light responsibility. That is a heavy responsibility, and they do take it very seriously. And when we've talked about this in the chat, all of you that have been on jury duty shared your experience. Everyone has said that you have taken it very seriously. Like, I felt the weight of this duty getting sworn in and sitting in court and looking at the attorneys and looking at the defendant and sometimes in court listening to the victim. People take it very seriously, very seriously. So no, I don't think they talk anyway. Once a verdict is rendered, then they can talk. 100%, then they can talk. Let's pull up that motion from the defense from yesterday. So yeah, jurors do take it seriously. I think this is the right one. Oh, that's the curative instruction. I heard about that. Do I not have it? Where did I put it? I know I grabbed it. That's the curative instruction. Let me see if I put it in the wrong file, which is 100% possible that I put it in the wrong place. No. Why? I must have. All right. Sorry, law nerds. I know it's thrilling to watch me look for things in my abundance of files, but I do want to go through that. For sure. So let me grab it one more time because it's probably on my desktop real quick. That's not it. That's the curative instruction. I know we grabbed it, Miguelina. I just don't remember where I put it. Because I have no idea where I put it. So let me grab it again because it was here. Regarding the missing witness, it caused a whole kerfuffle. I think I put it in our prep doc too. Miguelina, if you have that link, if you don't mind dropping it in there, that would be super helpful. But I'm looking to grab it again because I know that we had it, but I am trying to find it because it was a number of days ago. Let's see. Sorry, chat. I thought I had it exactly where I thought I had it, and it turns out that I don't. So I am looking, and I know the team is also looking, but it was in my prep. Apologies. It's the end of a long trial. Things get lost as I am looking for the motion for missing witness or for uncalled witness. I think I will find it. Let's just see if we can Control F. No, I don't see it. I thought it was in our prep doc. Miguelina, do you know if it's in our prep doc? Because I thought we had grabbed it and that you had linked it, but I do not see it. I don't remember which day. All right, I'm going to keep looking for it elsewhere if you don't mind looking in the prep doc for it. And we will come back to it. I'm going to answer some questions first as I try to find that, because I don't even remember what day it was filed. And I'm going to need to pull the docket for that, which is going to take me a second. So thank you, chat. Also, Amanda said, this is why we don't close tabs. Exactly. And then when everything crashed with the internet, all of the tabs that I had prepped for today got closed. And that was very, very frustrating. So we are just kind of stuck in it at the moment as I look for that document elsewhere, because I can't find it anywhere on my computer. And I know I had it. Let's see. Those are rebuttal witnesses. That's defense. I remember it caused kerfuffle, and I pulled it up and said, this is just about a jury instruction. This is not about anything beyond the jury instruction. And we talked about it then. Okay, I found it. We're just going to grab it directly from social media, which is not my favorite, but we're just going to do it that way. That's just how we're doing it. So give me a sec, chat, because now we have it, and it's hard for me to switch gears. So it's somewhere, because I had it pulled up yesterday. Lost. Not the curative instruction, Miguelina, the missing witness. That's all right. We had it. We don't at the moment. It's fine. We'll grab it this way, and then I'll re-grab it tonight. I was prepping last night. I didn't expect to lose internet and have to restart my entire system of everything. So is what it is. Let's pull this up and we will go through it quickly. Oh boy. So, missing witness. A lot of you have asked what happened. The defense withdrew it. We can look at the language and talk about why. Because the defense is no longer asking for the missing witness instruction. What does that mean? It means they're not going to have an instruction to the jury. This is the defendant's motion to present missing witness argument and request for subsequent instruction. They've withdrawn this. That doesn't mean they can't say who didn't get called. That doesn't mean that. But it means they're not asking for the formal instruction. Now comes defendant Karen Reed respectfully moves the honorable court to allow for the use of a missing witness argument. They actually might not argue it if they withdrew the whole motion. And subsequent instruction in her defense. All foundational requirements for a missing witness argument and instruction are met. Allowing Reed to present a missing witness argument would best position the jury to consider all evidence at issue. All foundational requirements for a missing witness argument are met. It is appropriate for the court to give a missing witness instruction, quote, where a party has knowledge of a person who can be located and brought forward who is friendly to, or at least not hostilely disposed toward the party who can be expected to give testimony of distinct importance to a case. This would be Trooper Proctor Higgins. That's who I read this to be talking about. Trooper Proctor Higgins. The Commonwealth could call them. The Commonwealth knows where they are. The Commonwealth knows where to find them and didn't call them. Where are they? If without explanation, a party does not call the witness to offer testimony, the jury may infer that the prospective witness would have given testimony unfavorable to that party. This is part of why they are not pushing this forward, I suspect. Because the prong is without explanation. I think there's an explanation for why Trooper Proctor is not being called. I also think that there is room for the Commonwealth to push back and say, hey, you could have brought them in as well. And I think that's exactly what the Commonwealth would have argued. You want to bring in Trooper Proctor? Bring in Trooper Proctor. Go ahead. Go ahead. Bring him in. The instruction to the jury would be, you can assume that the testimony from this witness would be unfavorable to the party that didn't call them. So that instruction would allow the jury to make an assumption that if the Commonwealth didn't call Trooper Proctor, it's because Trooper Proctor's testimony would be harmful to the Commonwealth. They've withdrawn the request for that instruction. And it seems that they've withdrawn the request to argue it, which is harder for me to wrap my head around. Why not argue it? So let us continue. This is the case law site. The underlying premise of a missing witness instruction is that a party's failure to call a prospective witness raises a reasonable inference that this witness would have provided testimony adverse to that party, and a jury should be afforded the opportunity to consider that information in their deliberations if they deem it to be reasonable. So giving the jury the instruction lets them make that assumption. And the jury is allowed to do that with the instruction. The instruction, again, has been withdrawn. The judge has the discretion to give it, fine. Oh, this is who they're talking about. Proctor, Albert, Higgins. All three. And then they argue the case law, and the defense says Proctor, Albert, Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of the three witnesses. The defense is informed that Albert and Higgins were both under subpoena by the Commonwealth. Isn't it interesting what's not in that sentence? Isn't it interesting what's not in that sentence? Was Proctor not subpoenaed? Interesting. The defense is informed that Albert and Higgins were both under subpoena by the Commonwealth. I don't know. That's what they're arguing. I don't know if that's accurate. That's how I interpret that. How else do you interpret that? We're informed that they were subpoenaed. So is Proctor not? I'm trying to grab, this is a great question, and I'm trying to just grab it. Trying to start. Cleopatra, I was trying to star your comment. Hold on. I'm trying to grab it. Our chat is moving, and I wanted to grab it, but it is fighting with me. So I'm going to hold it here so I have it. Miguelina, do you mind grabbing that question? Thank you. It's a good question. I'm just going to answer it now because I can't grab it well. Cleopatra in the chat said, Emily, can Brennan play the media clips of Karen during closing? 100% yes. 100% yes. It's interesting that Proctor is not mentioned as being subpoenaed. It says Proctor, Albert, and Higgins are friendly to the Commonwealth, meaning they're Commonwealth witnesses. All three witnesses testified cooperatively in the 2024 proceeding as witnesses in the Commonwealth's case. There's no reason to believe the individuals would not continue to be cooperative. So, hey, they are Commonwealth witnesses. There's no reason to believe that suddenly they're hostile witnesses. Let's see. Next page. Let's do it that way. As I said, friendly witnesses the year prior. Additionally, the fact that Reed could call these witnesses does not render the adverse inference impermissible, because the Commonwealth is more acquainted with these witnesses and would be naturally expected to call them in establishing their case. This is why you heard Yannetti arguing a while back. It's unheard of not to call the lead investigator in a murder trial. He was echoing some of these arguments that they've now withdrawn. They go on to say a missing witness instruction may be properly given where the prospective witness is more friendly to one side than the other, even if the witness was available to the party requesting the instruction, even if the defense could call them. They say that Proctor, Albert, and Higgins would each be expected to give non-cumulative testimony of distinct importance to the case. Each witness would offer meaningful testimony that is neither cumulative of other witnesses that have been called, nor would their testimony be unimportant. The Commonwealth would argue that it is cumulative. They would say, we established everything we needed to establish through Trooper B. The only reason to call these witnesses would be to support the defense case. That would be the argument from the prosecution, right? Why would we call them? All the evidence is in through Trooper B. Proctor's been fired. The only thing coming in through Proctor is those fucking texts. That doesn't help the Commonwealth's case. I think the Commonwealth would argue that calling these witnesses would actually harm their case. And so they would argue against giving this instruction because they would argue those witnesses are not friendly witnesses. So, interesting that it's been withdrawn. I'm surprised they didn't make the court rule on it. Truly, I'm surprised that they withdrew it. It's a strategic decision. The defense team knows what they're doing. It's an interesting strategy. They go on to say that Proctor's testimony would not be duplicative of other witnesses because if it's duplicative, then of course you would see the Commonwealth arguing, why would we call him? It's just duplicate testimony. They go on to say Michael Proctor was the lead investigator and responsible for recovering a significant amount of evidence in this case. They brought all that evidence in through Buchanan. They say that Buchanan's testimony confirmed that nearly every piece of evidence recovered in the connection with the case, including taillight pieces, was recovered by Proctor. They did. They did. Proctor is a necessary witness. My chat just froze on my software end, so that's a delight. Let's see what the next page. Let's see. That just goes on to Proctor's and Higgins' testimony saying it's not cumulative. Let me see what the next page says real quick. Well, let me see if I can pull that up. We're almost at the end of this motion. We're skipping ahead a page. They are arguing case law and then saying that the Commonwealth has not and cannot provide a sufficient explanation for not calling Proctor Albert Higgins. I think the explanation would be, excuse me, they're bad. They're bad for me. So they're bad for me. The Commonwealth understands the risk that the testimony of these three witnesses poses for their case, as all three are highly susceptible to impeachment on relevant non-collateral issues. The Commonwealth is consciously choosing to obscure and hide from the jury the complete picture of what occurred at 34 Fairview Road on January 28th and 29th. And the Commonwealth's argument to that's going to be, then you call him. Then you call him. Go ahead. You do it then. All three of these witnesses are susceptible to cross-examination regarding issues that are central to this case. Proctor's handling of the investigation in relationship with the witnesses and his termination from state police, prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview for a period of time in the early morning to look at photographs in some other part of the house, and then they listed other things that are redacted. Isn't that annoying? But I think those are going to some of the text messages. Let's see what their conclusion says. Again, this is completely moot at this point because they've withdrawn it. Let's see. This is the last page of their argument before conclusion. Depriving Reed of the opportunity to present a missing witness argument and denying giving the subsequent instruction would undercut her ability to present a defense. There is a critical distinction between argument by counsel that argument There is a critical distinction between argument by counsel that argument presented by the Commonwealth is insufficient. That is whoever edited that sentence forgot a step. And a missing witness argument. So they're saying that the argument of counsel to the jury is different than the court instructing it. A defendant has wide latitude in any and every case to argue that the Commonwealth has failed to present sufficient evidence and that there's an absence of proof or evidence is missing. A missing witness argument is distinctly different from this scenario. While both allow the defendant to argue that the Commonwealth did not meet their burden of proof, in the former, the defendant argues that the evidence that has been produced is inadequate, and this can legitimately include pointing out specific witnesses or evidence that have not been produced. However, in order to argue or ask the jury to draw any conclusions as to the substance of the evidence that has not been produced, counsel must first seek judicial consent to present such an argument and have a subsequent instruction follow suit. So in order to argue or ask the jury to draw conclusions as to the substance of the evidence that was not produced, they need permission. So what they are saying is, we cannot argue, they withdrew this, we cannot argue that those witnesses would have been bad for the Commonwealth, but they can argue, look at who the Commonwealth didn't call. So they have the distinct difference in argument there. So why did they withdraw this? Maybe because they think that their case is in a position where they don't even need to argue about this. That the tenor of their argument is going to be, what is the Commonwealth hiding from you? Look at who they didn't call. Not Trooper Proctor's bad for the Commonwealth. I know that might seem like a distinction without a difference, but as they're going through and writing their closing, this might have not been worth fighting on because of the way they're structuring their closing argument. If they are going to focus on the scientific evidence and that the car never hit John O'Keefe, which is what we heard in opening, if that is going to be the focus, that, and then look at what the Commonwealth didn't show you, look at who they didn't call, then they don't really need this. It just muddies the water. So that might be part of it. Let's continue on to the last paragraph here. They say a significant portion of Miss Reed's defense has been to focus on the inadequacies of the investigation into the death of John O'Keefe and the lack of consideration of other suspects. That's their Bowden defense. A judge is required not to take the issue of adequacy of police investigation away from the jury. That's the Bowden defense. Not affording Reed the opportunity to argue that the jury should draw adverse inferences from missing witnesses in the Commonwealth's case that are deeply involved in the investigation itself will erroneously remove from the jury's consideration the precise issue sought to be raised by the defendant. They've clearly changed their mind on that and withdrawn this motion. So in withdrawing this cancel. So in this change, no, cancel. I don't know what that is. I know you are. Stop talking to me. So the devices are now like, what's going on? The defense strategy of taking this, withdrawing this, has to be based on how they're building their closing argument. They are already, I'm sure, pretty deep into building their closing argument. And if last night they all sat down and went, okay, what do we need? What do we not need? I can understand the strategy of not fighting on this and fighting on the curative instruction over the Hoodie more. So this might be a choose your battles. LJR, I'm sorry to hear that. I can't pull up questions right now onto the screen because my software is not working. So I am sorry that I can't pull it up. I can see them, but I cannot pull them up because everything on that end has frozen for me. So if you sent a super chat and I cannot pull it up, I apologize. I'm having more trouble with the current chats. Some of the older ones are still here, but I can't pull up anything new. So that's delightful. I'm going to try to fix all of this before our members only live, which is going to be in a little bit. And I don't even know what is happening because I can't see anything. Lola the Good Dog said, don't worry, Emily, you'll find it. You are not a broken baker. I mean, my brain is broken today, and apparently the chat is as well because I can't see anything. So let's see. Emily, did you have the real John Stamos in your chat? Yes, that was the real John Stamos saying hello to the Lawnards, and I am so curious. Casey Cat, we're probably going to do, yes, like 3:15. Yes, it was the real John Stamos in our chat saying hello to the Lawnards, and the Lawnards had so much love. Okay, Miguelina, thank you. I just saw that in text. I appreciate it. We are all having the same issues today. Yep, we are all having the same issues. Carrie said 1 million signing bonus to be, I don't know who that is, defense lawyer, one of our favorite. I don't know. Carrie, I have no idea. Also, it would mean I wouldn't be streaming. So the answer is going to be no. I very much like streaming. Though it's the same way when people say, Emily, you should be a judge. I'm like, in the style of Judge Judy, maybe. But beside that, no, it's so much paperwork. It's so much paperwork. Judges do so much paperwork. And I am very ADHD. Decision fatigue is real. All judges do all day is make decisions about all kinds of stuff. And like stuff that applies to the cases they're handling, stuff that applies to operation of the courtroom, stuff that applies to the paperwork that it's no. So no. In the style of